Okay, good morning. We are back in session. The lawyers are present, the defendant is present, and the jurors are all here and ready to be brought in. Are both sides ready, State?
Ready, Your Honor.
Okay, defense?
Yes, ma'am. Our first witness is a Zoom witness, but I believe that there's an outstanding motion by the state pertaining to some information by that witness.
That's correct, Judge. We filed back before the beginning presentation of the defense case. I don't have this number. It was motions to strike certain slides of Dr. Connor's PowerPoint, and the defense has been on notice of many of those slides. We received last night a new PowerPoint slide where some of the original slides we objected to were removed. However, there's still many left in the PowerPoint. Being that Dr. Connor is about to testify, we'd like to have this motion heard so that those slides.
Why is this just being brought to my attention now?
Judge, we filed the motion 2 weeks ago.
But nobody asked that it be heard. We had last week to hear this. Now I'm sitting here, the jury's ready to come in. So do you have another witness that you can call in the meantime?
No, ma'am.
Well, how soon can you get one here? Because I'm not gonna sit here and litigate something for an hour and keep these jurors waiting. It's not fair.
Judge, we don't have another, we have another witness coming this afternoon, but we had 2 long witnesses today, and we just.
How long is this gonna take?
I don't think very long, Judge. The arguments are the same for every slide. The court's already familiar with the case law because I relied on it last week when Dr. Scully testified. So it would be the same case, that Lynn V. Fossum case at 946.
I don't remember. You have to remind me who that witness was and what the testimony at issue was.
She was the toxicologist, and she was attempting to rely on several studies, research treatises, in her testimony. I objected to the court sustained
The
my
lady who
objection.
bought something online, she was blonde?
Yes. There were studies regarding Cisco in the early 90s.
Okay, I remember.
Your Honor, if
Yes.
I may also,
Sure.
there's 2 slides in particular regarding Dr. Connor's testimony. It's on pages 25 and 26, where he specifically refers to Brenda Woodard's statement to Dr. Heather Holmes. And that is double hearsay, and that is something that is a very brief argument because it is something that is double hearsay, even though the rules are relaxed for a penalty phase. Double hearsay where the state is unable to cross-examine or rebut a declarant who is deceased, who is Brenda Woodard, that testimony is not admissible. And that is something, we're only talking about those 2 specific slides, and 25 refers to a summary of Brenda Woodard's testimony, and the state would ask that that be removed wholesale. And regarding slide 26, where he talks about the basis for his opinion, he has, I believe, 4 or 5 bases for his opinion, and one of them is Brenda Woodard's statements to Dr. Heather Holmes. It's called The Interview of Brenda Woodard by Dr. Heather Holmes. That should be removed from the PowerPoint. And I would also point out that points number 3 and 4 of the PowerPoint on page 26 need to be cleaned up because an expert cannot rely as a basis for their opinion as a hypothetical, anything that has not been admitted into evidence. And I have a case for the court and that is Door Bad, and that would be 12 Southern 3rd, 255, Florida 1st District Court of Appeal, May 2009, Your Honor. So the PowerPoint on page 26 needs to be cleaned up as to number 3 and 4, and number 5 regarding the interview of Brenda Woodard by Dr. Heather Holmes needs to be taken out because it is based upon double hearsay by a declarant who is deceased, and under the case law of Florida Supreme Court, it is Hitchcock and Carr. The cases are legion, Your Honor, that the state, even though the rules are relaxed for the penalty phase for the defendant, the rules apply equally to the state. You cannot have the subject matter coming in through a witness who talks to a declarant who is deceased, who the state has no opportunity to cross-examine or rebut. And I would point out that the subject matter of Ms. Woodard's conduct during her pregnancy has already come in through Ms. Deakins and through Danielle Woodard. So this is not a case where the state is asking for the wholesale exclusion of mitigation evidence at a penalty phase. Far from it, Your Honor. It has already come in. It's going to continue to come in through fetal alcohol syndrome testimony, but specifically if the statement made by Ms. Woodard to Heather Holmes comes in, that is inadmissible hearsay, Your Honor. And we would ask that the PowerPoint and testimony regarding that conversation be eliminated in the PowerPoint on pages 25 and 26 and from the testimony of the witness.
Well, can the witness not rely on it just based on the fact that it's been testified to and it's a matter of the record in this case? It's in evidence, the statements by I don't remember the lady's name, but the lady who observed the biological mother doing certain things?
If this testimony is already in through Ms. Deakins and through the daughter. So if the PowerPoint is cleaned up.
In other words, you're not objecting to the expert saying, I have this information, and based upon this information, my opinion is X.
Correct.
But you don't want him to say, I spoke to Dr. Heather Holmes, who spoke to Brenda Woodard, who got this information in this way.
That's right, because that is inadmissible hearsay. He can say that, he has information through the testimony of a witness who's already testified, and that would be Carolyn Deakins and the daughter, Danielle Woodard. But the PowerPoint talks about the deposition of Carolyn Deakins and the affidavit, which is not admissible.
Remind me who Carolyn Deakins is?
Carolyn Deakins was the friend who they shared an apartment and
From
a lifestyle
Kentucky?
together.
She lives in Louisville, I think she said?
Yes.
Oh, I remember, okay.
Right. So that testimony has already been, that's part of the evidence in this case, but to rely upon something as part of a hypothetical, and I would, again, the Doorbad case, Your Honor, it's not appropriate for an expert to rely on part of a hypothetical on evidence that has not been admitted. We have no objection to the subject matter coming in. It's already in, but the PowerPoint needs to be cleaned up.
May I just consult Ms. McCann?
Sure, I mean, it seems to me like that can be done pretty easy. My assistant's out, I apologize for this, but did you all file a copy, or did you give me a copy of the PowerPoint? And can you let me know what day so that I can pull it up on the clerk's computer, please? Or is it attached to something?
May I approach it?
Sure.
I have a copy. And I think.
Can I have
Mr.
it?
Sats, yes, you can have it. I think Mr. Sats gave you one of,
But then I gave it back.
yes, and that one is actually marked, but disregard the mark in the back. In the back, there's a sticker.
Okay, I'm gonna take it off. But this is exactly what we're litigating right now.
As in its entirety, however, I don't know what slides were taken out last year. I can ask Mr. Teacher if he can take them out. Do you want me to do that?
Please. Thank you. Should there, like, somebody dropped him or something?
How you didn't pass that on my mom?
Yeah, and I've been here since 8:30.
I know, we know.
I could have been, how do you know?
We heard.
You know.
Not even a minute.
Do we start a Zoom?
I'm sorry?
Do we start a Zoom?
We would like to, but I think we have more.
Okay, so I'll wait.
Maybe not.
Unsolved number 26.
The page that you have with the number 26 encircled,
Yes, ma'am.
that's no longer an issue.
Yeah, it was amended to the state's satisfaction, if I understand correctly.
That's true, Your Honor.
Okay,
The preceding one, number 25, is still at issue, Your Honor.
okay, so the state's saying that this is an interview of a person who is deceased. Actually, it's double hearsay. It's an interview by someone who's not testifying of a person who is deceased. They don't have any opportunity, they do not have the opportunity to confront this witness. And what is your counter argument?
My counter-argument is, first and foremost, that Ms. Woodard was alive for a great deal of dependency of this case, so the opportunity to at least interview her did exist. Secondarily, based on the Doorbad case that was cited by the state, there's a section of that case that states that when an expert is testifying on evidence he or she has not personally observed, the expert may state an opinion based on record facts, as long as those facts are supported by evidence that has been or will be introduced at trial. So despite the fact that those statements from Ms. Woodard to Dr. Holmes are not in evidence now, they will be, because Dr. Holmes is going to testify. And so I would argue that pursuant to the Doorbad case, that it would be perfectly acceptable for Dr. Connor to rely upon that information obtained from Dr. Holmes, because it will be in evidence.
Well, it would still be hearsay, it's just not double hearsay then.
Yes, ma'am, and regarding the hearsay issue, I mean, I know the court's aware of this, but I would reiterate that hearsay is admissible in a penalty phase, and that the evidentiary rules for exclusion are relaxed during the penalty phase. And this is relevant mitigation, particularly pertinent to the issue of fetal alcohol spectrum disorder. This is an admission by the biological mother, which, you know, I think a lot of people would consider to be the most reliable.
Okay,
Your Honor, if I could, I just want to put on the record here
sure.
that the defense's note about Ms. Woodard, they did not list her as a witness. They knew she was sick. They did not move to perpetuate her testimony. She died before the defendant pleaded guilty in October of last year. It appears that the defense has done everything in their power to keep Ms. Woodard from the state. The defense did not raise the specter of fetal alcohol syndrome and list their witnesses until after the defendant pleaded guilty in October. So her conduct during her pregnancy was not relevant to these proceedings until they raised the specter of fetal alcohol syndrome, Your Honor. Ms. Woodard is now deceased. The state does not have an opportunity to cross-examine nor rebut anything that she said to Dr. Heather Holmes when she was alive. And the defense, knowing that that testimony would be important to them, had her statement taken by Ms. Holmes, Dr. Holmes, and yet did not list Ms. Woodard as a witness, did not move to perpetuate her testimony, and did not raise fetal alcohol syndrome as a defense until after the defendant pleaded guilty. The state is foreclosed from ever cross-examining Ms. Woodard or rebutting her testimony. It's inadmissible under the Florida Supreme Court's decision in Hitchcock, which says if the declarant is deceased and the state is unable to cross-examine or rebut the testimony, that the testimony is inadmissible. And I would also point out that there's this Florida Supreme Court case, Francis versus State, where there was a defendant and a co-defendant, and they gave statements to a mitigation specialist about the defendant's abusive childhood. And because the state was not in a position to cross-examine the defendant about the statements he made to the mitigation specialist, the trial court was within her discretion to disallow that testimony. And the Florida Supreme Court noted that the subject matter of that testimony was able to come in. And that's exactly what we have here, Your Honor, except we have a situation where the defendant, albeit is available, but he certainly has a right not to testify, and it's not the same as the Francis case, but we have a declarant who is deceased, who absolutely cannot and will not be cross-examined or rebutted. So, we have a situation, Your Honor, where the state has totally foreclosed, and yes, the rules of evidence are relaxed in a penalty phase, but they're not thrown out the window. And this is where the defense wants to cloak inadmissible hearsay and imbue it with credibility when the state is totally unable to cross-examine or rebut it. And we can't litigate this with both of our hands tied behind our back. And it's clearly not admissible, Your Honor, and the Florida Supreme Court has held it's not admissible.
Okay, I think there's an easy solution to this. I agree with the state, based on the case law, that these statements by Brenda Woodard to Heather Holmes is double hearsay, it cannot be rebutted. However, if you just reword the slide, so it says something to the effect of biological mother used crack cocaine and drank alcohol during pregnancy, period. You're getting the same information through. That's information that was testified to from the lady from, who, I can't remember her name, but she currently lives in Kentucky. She was, I guess, for lack of a better way of saying it, was working with the biological mother during her pregnancy. And she already testified to that. So, Mr. Secor, just leave it at that.
I understand.
I mean, you don't need it. Why do you need any of the other stuff?
Well,
I believe that witness testified that she smoked crack and that or snorted cocaine, I forget which one.
it was crack.
And that she drank, she even told the kind of alcohol she drinks. So just edit the slide so that you're getting the same information. He's relying on the same information, but it's not hearsay and it's not all these statements of the mother, which I don't think you need anyway.
I understand the court's ruling. I do think that it's compelling to have actual phraseology from Ms. Woodard, and that's why I think that it's important, but I understand that the court is ordering me to change the slide based on the wording, which I will do. And as a means of saving time, I'm going to, in the event that the court has other rulings to edit or remove some of these slides, I'm gonna have an objection, but I don't feel the need to make it each time. Is it okay if I just make it at the end?
If it's based on the same law, my understanding is that although hearsay is admissible during a penalty proceeding, that the opposing party has to have some type of opportunity to rebut the evidence. And that's been my ruling on, please don't talk when I'm talking. Thank you. That's been my ruling throughout. If you want to just maintain your objection, if that's the same thing, and I can propose a way to modify the slide. You don't have to do it exactly how I'm saying it.
No, I understand. I mean, I will do it. I will do it as your Honor instructed, and that's fine. I just maintain my objection to that. My reading of the statute, specifically on penalty phases, regarding the opportunity to rebut hearsay applies specifically and solely to the defense, given what the defendant faces as a consequence in the penalty phase versus what the state faces. So that would just be my objection.
Okay,
Thank
so
you.
your objection is noted.
Thank you.
What, besides 25, which I've just ruled on, and 26, which you all have, 26 was the one you agreed to, I believe.
Yes, ma'am.
Okay, what else is at issue?
So Judge, the remaining slides would be the objections that are similar to last week with respect to the Lindy Clausen case. These slides contain references to outside sources.
Just tell me the number of the slide,
Okay.
and then I'll read it, and I'll let you know if I have any questions.
Oh, it's slide number 2.
Okay, and what is your objection to slide number 2?
It is referring to a outside source, as some type of treatise or study. It says at the bottom, this, prior to late 1990s, and that is one of the types of sources that is prohibited under 90.706. This is a study that would be used only to bolster Dr. Connor's opinion. It's not proper for direct examination.
Why can't an expert witness rely on a learned treatise, in their opinion?
Because he can testify where he got his opinions from, but to have it on a slide is.
Oh, I see, by stating the
source.
NDPAE.
If I may,
And you, hold on just a second, you said 9706?
Yes, Judge.
Give me just a second, please. So where are you specifically, I guess you're intuiting it? That it says you can't print it out like this on a slide? Because I don't see where it says that.
And the expert can rely
Intuited
to
it.
whatever,
I was trying-
whatever
like,
sources they're
She
looking.
intuited it, right?
I may be.
I should have used another word, but I think that's the right way to say it. She intuited it. Like you are reading
I know
into
what
it, you're inferring it, you're, right?
I know-
Anyway,
I
forget the word I used.
The,
That-
the expert can arrive at their opinions by referring to sources, of course, but when you put them on a slide and put them in front of the jury, that is bolstering their opinion with a treatise, and that is what is prohibited by 9706. And that is what is in Lynn v. Fossett. And it says clearly, experts can testify that they form their opinions in reliance on sources that contain inadmissible information without also conveying the substance of the inadmissible information. Under section 90.706, which allows the use of authoritative literature on cross-examination, only on cross-examination, it is inappropriate to allow experts on direct examination to bolster their credibility or to supplement their opinions by testifying that a treatise agrees with their opinion.
So according to 9706, you can use a treatise to attack an opinion as substantive evidence, but you can't use it on direct examination, and you can't, and it's hearsay if offered as substantive evidence.
Your Honor, if I may briefly, this is not a reference or a citation to a treatise. And maybe it's just the appearance of the slide, but underneath the red box where it says called fetal alcohol effects, FAE, prior to the late 1990s, that is simply Dr. Connor pointing out that that the diagnosis of NBPAE used to be called fetal alcohol effects. He put it in quotes, I think just to indicate that that was the phraseology that used to be used, but this is not a treatise, this is not a reference to some other authority, this is just something that he created based on his
Okay,
knowledge of these
so we
conditions.
could have just circumvented all that. It's not a treatise.
Well,
It's just saying what it used to be called.
and so this, what I'm hearing from Mr. Secor is this chart is created by Dr. Connor, and it's not pulled from a book?
Yes, ma'am.
I'm not able to tell that, and when he has a reference to prior 1899, it looks like it's pulled from a book.
Okay, so your objection to slide number 2 is overruled. What is the next one, please?
Slide number 3, same objection. And there's clearly a reference to a treatise at the bottom of the slide.
Mr. Secor, do you agree that it's a reference to a learned treatise on the bottom of the page?
I do, Your Honor. I would just argue that it is admissible and relevant as a way to illustrate what Dr. Connor is going to be testifying to, and specifically Florida Statute 90.704 says that facts or data that are otherwise inadmissible may not be disclosed to the jury unless the court determines their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs their prejudicial effect. I would argue that there is absolutely no prejudicial effect of a slide such as this to even be weighed against, and the probative value is strong because it is an illustration to help the jury understand Dr. Connor's testimony. Dr. Connor is a neuropsychologist, and in my communications with him to learn this information, it took a great deal of me reading
But
things.
how would the jury be assisted? I'm telling you, as a lay person, I can't make heads or tails of what those 2 sentences say.
Yeah, the sentences, I agree with you, that's just a citation. The images are
The
of,
state, you're not objecting to the images, are you?
Judge, they're not of the defendant. This has nothing to do with the defendant.
the images, Your Honor, are of a mouse fetus that was exposed to alcohol in utero, and it shows the cell death that occurs within 12 hours of exposure to in utero alcohol. And the dark spots on the slides are the cells that have died as a consequence of being exposed to alcohol, and the concentration of the cell death is in the part of the mouse fetus that would have become the face, brain, and head of the mouse. And that's how we know through animal studies that alcohol exposure affects that brain and face of people. We can't do human studies because we can't force pregnant women to drink alcohol and poison their children, but we use rats and mice.
I understand, let's not get off topic. Is it
I'm sorry.
hearsay or is it not?
Is it hearsay?
They're saying that it's inadmissible hearsay, you can't admit it as substantive evidence, he can incorporate it into his testimony as something that he relied upon, but you can't present it in this manner. That's all I wanna know.
My argument would be based on 704. It is specifically admissible because it would assist the jury in understanding the expert's opinion.
I disagree, Judge. I don't think there's any value in this. to
But
the
value
jury.
or not, that's not, I just read the statute, it doesn't talk about whether it's valuable, it talks about whether you can do it.
It still needs to be relevant, and if it has nothing to do with the defendant, it's not relevant.
So the actual, what did you call it, a mouse fetus?
Yes, ma'am.
The picture of the mouse fetus, you're not objecting to those pictures, but you're objecting to the, where it states what treatise that those mouse fetus pictures came from?
I'd be objecting to all of it, because I don't see.
Okay, but on what grounds? I understand the grounds, the listing, the learned treatise, and the name and the page number, and when it was published, and that, all of that. But on what grounds are you objecting to the 2 pictures of the mouse fetus?
So Dr. Connor's testimony is gonna be, this is of a mouse fetus that was exposed to alcohol?
And related, I am going to assume, to the defendant.
And how does he know how much alcohol this mouse was exposed to, how long the period of time, what was the studies like? I mean, there's just no information here related to the defendant.
Well, we'll have to handle that as it comes. So for now, I mean, I don't know what the guy, I don't know what, is it a man or a woman?
Ma'am.
I don't know what the gentleman is gonna testify to. I can't rule in a vacuum. I have no idea.
I-
But
I
we need
can-
to take out the part on the bottom that lists the treatise and the page number and the dates.
Yes, ma'am.
Okay, what's the next slide that you have an objection to?
The number 4, Judge,
So it's every slide in this.
it's about half the slide. It's 21 slides.
Okay, number 4, you're objecting. What's the basis of your objection?
It's the same objection, Judge. This looks to be pulled out of a book or a treatise, and it's just going to bolster Dr. Cruz's testimony.
Did your expert make this?
Anything without a citation, I believe Dr. Connor made for the purposes of illustrating his testimony, for helping the jury to understand it. And this is simply points out that alcohol is a teratogen.
I see it. If he made it and those are based on his opinion and his work on the case and it's gonna aid him in explaining it to the jury, I'm overruling the objection. But will you please just make sure?
Yes, ma'am, I
Thank
absolutely
you.
will.
All right, what's the next objection?
Case number 5, Judge, these are the Institute of Medicine guidelines.
And what's the basis of your objection?
This is an outside source, it's a treatise, it's guidelines for the Institute of Medicine, and it is solely in there for the purpose of trying to bolster Dr. Connor's testimony.
Your Honor, if I may, Dr. Connor uses the Institute of Medicine guidelines for purposes of structuring his diagnosis. It's the diagnostic formula that he follows, and so I think he's entitled to show the jury what the diagnostic formula is, and then he's going to apply it to Mr. Cruz as a way of illustrating the process by which he arrived at his conclusion. So he's not using it to bolster anything. He's saying these are the criteria that I use in conjunction with the Center for Disease Control guidelines on the next page. So I don't think it's definitely not an attempt to bolster. He's just saying this is what I use. It would be like a doctor saying I use the Diagnostic and Statistical Manual criteria to diagnose a person with condition X.
State, would it be any different than the doctors testifying? In his field, they rely on CDC guidelines and IOM guidelines, and they're as follows, and then he gets up and writes them down on a list for the jury as he's explaining his testimony. How would this be any different?
Judge, I think the purpose of 90.706 is that he can arrive at those conclusions, but it's taking it a step further to then blow up the guidelines or any type of information out of an authoritative source and say, so here, look, it says it right here too. That is what is prohibited.
What about slide number 7? State, are you objecting to slide number 7?
No, Judge.
All right, I'm gonna allow the defense to use slides number 5 and 6. 7, there's no objection. What's the next objection, please?
13, Judge.
So there's no objection to 8, 9, 10, 11, 12. And what is your objection to number 13?
There's a reference to a study, 1, 2, 3, 4 bullet points down. It says, looking for significant deficits, more than 84% of the population performed better. That is the objection.
Your Honor, if I may.
Sure.
That is just a reference to a person who has a deficit of 1 standard deviation. 1 standard deviation would mean that 84% of the population performs better on a given task. essentially a way to identify what a significant deficit is. It's more than 84% of the population perform better.
Is this essentially, you're just making bullet points of his testimony, correct?
Yeah, well, and these are the bullet points that he put together as a way to illustrate what he's talking about at the time.
All right, your objection to 13 is overruled. What's your next objection, please?
Page 14, second bullet point, determine consistency with research on FASD. That's not Dr. Connor's research, and that is referring to, I don't even know what research, there's no citation. I would,
Is that something he's gonna say that he does, identify the pattern of current strengths and weaknesses of the defendant, then just determines consistency of the strengths and weaknesses with research?
Yes, ma'am. And he's been involved in FASD research for 30 years. And the way that part of the assessment process is that you determine whether or not the person that you are assessing performs in a way that's consistent with people that you know to have FASD. That's one of the ways that you are able to identify whether or not their impairments are consistent with a person who has FASD. And so when he's talking about determining consistency with research on FASD, he certainly is referring to his own research that he has done himself in conjunction with other entities and universities.
Okay, I'm gonna overrule the objection without prejudice. Obviously, if something comes out during the testimony that you think is objectionable in and of itself, or the way that it is testified to or relayed to the jury, you can renew your objection.
thank you, Judge. Next page is 15. Same objections. These are outside research findings. I don't know who conducted them. I don't know if Dr. Connor had anything to do with it. This is, to me, highly bolstering of anything that he's going to testify to.
Where is he getting this information?
These are things that he has identified in his 30 years experience working in the field of FASD.
All right, but based on that representation, I'm going to overrule the objection without prejudice. What's next, please?
Page 16, Your Honor. There's a citation there at the bottom. It appears this is from some treatise or authoritative source.
It is. This is a study that was done on alcohol-exposed chickens, and is a way for Dr. Connor to illustrate to the jury some of the cognitive deficits that are suffered by a person or a live being that is exposed in utero to alcohol. And it's just an illustrative study that highlights the point, particularly about the impairment in memory caused by in utero alcohol exposure.
All right, to 16, I'm overruling your objection without prejudice.
Judge, I'd just point out the study is 1989, 40 years old.
Well, that's a point you can bring up on cross-examination. What is this, what's the next objection?
Next slide, 17. Again, this is pulled out of some source. I don't know.
I'm sorry, I can't
I'm
hear
sorry.
you.
It's, again, same objection. It's pulled from some source unidentified, or I don't know who conducted this research, when it was conducted.
I don't know either. Where did this come from?
This is, again, partially what Dr. Connor has found in his own practice, but also has been recreated by others. And
I mean, I'm assuming this IQ type chart is a generally recognized variable within the field. I mean, State, are you saying that this chart is not accurate? I mean, I don't know.
I don't know if it's accurate or not. I also don't know where, if it's a group of studies, one study. There's specific numbers there, so these have to be a bunch of different groups of controls. I don't know if was subject to peer review. I don't know if it was subject to proper scientific method procedures. But this is, going to be, again, highly bolstering of Dr. Connor's opinion.
But if
All
these,
these outside sources of information.
this is the type of thing, IQ scores are the type of thing that are, when you ask, at least in my experience, I've had, I don't know, 5 or 10 or 20 psychologists testify to IQ, and the ranges are generally accepted. If you fall within this range, you're, what do they call it, intellectually disabled now, right? Not borderline ID, or just above, and I'm not saying exactly what it is because I'm not a psychologist, but aren't these numbers in these ranges things that are generally accepted and
I cannot say that, and also whenever you're conducting a test, whether it's IQ or neuropsychological or whatever, certain protocol has to be followed.
Sure, but
How
the-
they derive this number, I don't know if that protocol was filed.
I don't think
Followed?
that there is a number. I think this is just a chart saying how to determine IQ, no? Okay, so then I'm mistaken. Does this have Mr. Cruz's IQ on it?
No, ma'am, but this chart was made by Dr. Connor. It has been published and consequently subject to peer review, and it merely is a visual aid to show that the bell-shaped curve in the back is a normal distribution of IQ
Oh, this is
scores.
IQ as it relates to this FAS?
Yeah, the red bars are people with fetal alcohol syndrome. The blue bars are people with fetal alcohol effects, and then the black line in the back is just the normal distribution of IQ. And so it's just designed and created by Dr. Connor based on his research and experience showing that people with FAS have a lower IQ and people with FAE have a lower IQ. And it's in a similar sort of bell-shaped curve.
Okay, state, this goes to weight, not admissibility. The points that you're making, you can make those points on cross-examination, but I don't know any of the answers to any of your questions either. That's why my rulings are going to be without prejudice, because I'm going to assume there's going to be some type of foundation laid before he's going to testify to this.
Judge, and I understand the court's ruling, it's just, again, when this type of research is put out there for the jury, there are certain protocols that have to be followed. And I don't have this study in front of me or to cross-examine on whether that was done properly. So in other words,
Well, did
Dr. Connor's just gonna get up there and say, I relied on this, or, this is solid research. How do we know that?
I don't know, did you ask him about it in deposition?
We just got these PowerPoints last night.
They specifically talked to him about it in his deposition.
As to this particular slide,
Yes, ma'am.
17?
Yes, ma'am. They went through every single slide.
Would you please be so kind as to refer the state to the area in the deposition, if that's not too much trouble?
Yes, ma'am.
You know what, if, maybe Ms. Basham, can you work on that while we keep going, and we'll put this one aside, and then you can refresh Ms. Chiappone's memory, or you can agree to disagree, or,
And what was the number of the slide?
it's number 17. Okay, what about 18?
Yes, Judge. This is, referring to the DSM-5.
So it's a quote from the DSM-5.
Yes, ma'am. This is verbatim from the DSM-5, and it is simply in there to point out to the jury what Dr. Connor uses for purposes of assessing adaptive functioning. So it's not designed to bolster his opinion or somehow say that he's right. He's saying this is what I use when I'm assessing the issue of adaptive functioning.
Yeah, but, see, I agree with the state on this one, as far as 9706, because you're using this as substantive evidence, saying this is, and maybe this is the only one that I can relate to, because it's the only one that I've heard of, the DSM-5, and you're saying, look, according to the DSM-5, and in fact, I'm underlining it in red, this is being used as substantive evidence. He can testify to this, he can testify that he has, to his opinion and what he's considered, but as far as, quoting something like this, I'm going to sustain the objection.
Judge, may I get up for a moment to do something?
Sure. All right, how about 19?
Yes, Judge, this is a secondary disability study.
And
And
Judge,
you're,
this-
what's the objection? I'm not familiar with these things like you all are. I mean, I know some things from,
It's just the same objections, Judge. I don't know, I think this is a 1996 study. I don't know how it relates to the defendant. It appears to just be offering Dr. Connor's opinion.
did you have, I'll ask the same questions. Did you have the opportunity to question the witness in Depot 1? 2, if you don't think you did, and there's a disagreement, can we find where it was asked?
I would just add, Your Honor, this is a chart that was created by Dr. Connor. It has been published.
So the witness, this is his own handiwork
Yes, ma'am.
in number 19.
Yes, ma'am.
But what about, it says that WRAT, and he didn't, he didn't invent these scales and tests.
I'm sorry, you still think
You
that-
said this is his own work,
Yes,
but
ma'am.
he's referencing specific scales and achievement tests within this.
Yeah, these are, across the bottom are tests that are given. Those are published, accepted tests. And then what the graphs show is that people, one of the box on the left is for people with fetal alcohol spectrum. And they tend to have an average IQ of around 80, and then their intellectual and adaptive behaviors then drop off lower than 80. People with fetal alcohol effects generally have IQs of 90, but they have a similar pattern of their academics and adaptive functioning dropping off precipitously, which is the point being that people with some degree of prenatal alcohol exposure, they have a IQ that's normally not in the intellectually disabled range, but they end up performing in school and in daily life.
Mr. Secor, I'm gonna learn all about this all day today, I'm
sorry.
quite certain. No, I'm not being fresh, I need to know, this is his own work, so you're saying it's admissible because this is something that your doctor came up with, it's not something that he took out of a book and printed.
I mean, it is published, but it was published by him as part of his research.
Does that change your position?
Yes, because, or no, because again, it's research that I don't know how it was conducted. I don't know if it was peer reviewed. The defendant has nothing to do with this study. I think it's proper to be excluded under 90.706.
I would just say it's page 40 of deposition 2 where these slides were discussed.
Yeah, Judge, it starts page 40 and goes for a little while.
Okay, one at a time. All right, on page 19, I think this goes to the weight, not the admissibility. I'm overruling the objection. Page 20, state you have an objection to this slide too.
Yes, Judge.
And let me just ask the defense before I hear your objection. Is this something that your expert came up with on his own, or he took this out of a learned treatise and
No,
photocopied it?
This was created by Dr. Connor based on his experience and research.
And he's made these graphs to explain his testimony.
Yes, ma'am.
All right, the objection to number 20 is overruled.
I think we've taken care of 25 and 26, Judge.
Excuse me?
I think we took care of 25 and 26.
We did. So what is the next objection, please?
So it would be page 29.
what is your objection, please?
The reference to the research average score for FAE equals 90. Down on the bottom.
Where did that come from, Mr. Secor?
Dr. Connor would know it as a consequence of his 30 years of working with people with fetal alcohol spectrum disorders. I can find out from him whether or not he actually meant to reference a particular treatise, but my understanding is that is something that he has learned based on his 30 years of experience that people with fetal alcohol effects tend to have an average IQ score of 90.
Based upon research that he has conducted himself, he's going to testify that based upon his training and experience and education and so on and so forth, that the average score is 90.
Yes, ma'am.
All right, your objection is overruled to slide number 29. What's next, please? And again, my rulings, whether they're for the state or for the defense, are without prejudice, because this is the first time I'm seeing this and hearing this. I'm gonna be paying close attention when the expert testifies, or the witness testifies, so I'm assuming I will have a better understanding of this subject matter as we go, and there could conceivably be something that comes up where I'm gonna change my mind or not. I just, it's hard to do this in a vacuum.
I understand that.
And that's through no fault of anyone's, it's
No.
just the way it is. Okay, what is the next objection, please?
Slide 42, just says consistency with FASD research with no reference to anything.
I'm sorry, Mr.
I'm
Mahoney, I
sorry.
can't hear you.
Slide 42, it just says consistency with FASD research with no reference to anything.
This is merely designed as just a heading, a transitional heading, so that the jury knows that that's what we're about to talk about. That's literally all it is.
Except that consistency, it's almost like if you compare it to a consistent statement, it's like, okay, I'm about to make something consistent. I'm about to tell you something that's consistent with something else. In and of itself, that word,
Okay.
you need to take that out, please. 42, the objection is sustained.
Thank you, Judge.
And then what is the next objection, please?
That would be slide 47.
47?
This is again, a 1996 study. I don't know who it was conducted by.
Is this his own
Yes, ma'am.
work?
It is.
So this is something that the defense witness is going to testify to, that he's come up with on his own.
Based on his experience and research, yes, ma'am.
All right, 47, the objection is overruled. What is the next objection, please?
Slide 51.
Okay,
Specifically, there's these normative groups, and this is research from, it looks like Robridge and Brown. Those are outside sources, research that Dr. Connor obviously did not conduct, and I would ask that it be not admitted or prohibited from the jury seeing it.
You want me to ask the top of them?
sure. All right, your objection to 51 is overruled without prejudice. What's the next objection? Because I need to be able to hear that in context. I don't know how he would testify to Mr. Cruz's numbers without being able to compare them to something, but I need to be able to hear what it is and the basis of it before I can rule intelligently,
Understood.
okay?
Slide 53. This is a study, it looks like by Dr. Khalifa.
And what does that mean in the justice system? That's a little,
And it's people that with either pending criminal charges or criminal convictions.
but, I mean, federal court, state court, international court? Are we talking in the last 10 years? Are we talking with pending cases? Are we talking with people who have been previously convicted? Are we talking career criminals? Are we talking only people charged with homicides? This is, the justice system is very vague.
I agree, and I can't answer all those questions. Like, it's not international. It is, my understanding is that this is an article that identified commonalities of impairments of people in the justice system who have an FASD. That's the simple point of this slide, is to illustrate that those are the impairments that are shown by a great deal of people in the criminal justice system that have FASD, and then the question is whether or not Nick has similar impairments. So again, as Your Honor said, it's a way to compare Nick to that group of individuals.
Judge, this was not done by Dr. Connor. I have no idea what groups he's chosen to compare him to, how many subjects were part of those studies, whether they were done properly. I mean, this is highly prejudicial.
It's in a published article, as indicated at the bottom of the slide.
I know, but in its current form, the way it's phrased, it's almost insinuating that his profile was compared with everybody in the criminal justice system, and we all know that that wouldn't be possible. And so he can, if he wants to give an opinion based on and incorporate this study into his opinion, I may or may not allow that, but I think that this slide in and of itself is inadmissible hearsay. So I'm going to exclude this without prejudice.
Thank you, Judge. This next
Well,
slide.
the slide itself, I think, is inadmissible. However, I could conceive a situation where he would be able to testify by incorporating this into his opinion, as a basis of his opinion. But in its current form, I'm going to sustain the state's objection.
Judge, may I step up just for a moment?
Sure. What
Next
is-
one is 54, Judge. It's the same, looks like, I don't know if it's the same study by this Dr. Khalifa, but same arguments as we made with.
What does that mean, comparison with Flanagan?
This graph was made by Dr. Connor based specifically on a graph that was created by a state expert, Dr. Gilmet. He made a bar graph based on the Flanagan study, and specifically cited the Flanagan study in the documentation that he produced on behalf of the state, which was turned over to us. Dr. Connor took Dr. Gilmet's
So,
bar graph.
I'm sorry to interrupt. So Dr. Flanagan is the state's expert?
No, Dr. Gilmet is the state's expert. Dr. Gilmet made a bar graph based on the Flanagan study. Flanagan is a study that was published in conjunction with the Khalifa article from 2021. So Dr. Connor made this as a way of looking at the same data that Dr. Gilmet put together for the state, but showing, he added that green area around the testing as a way of showing the ranges that people with impairments function within. So it literally is the exact same thing that the state, I assume, would want to present to the jury. But Dr. Connor has just added onto it to show that range of above and below the means of the people represented in the Flanagan study that Dr. Gilmet cited.
Okay, if this is something that he came up with on his own, based upon his research, then I'm going to allow it. But the whole first two lines, comparison with Flanagan, ETAL 2019, and the study of Khalifa 2021, that needs to be removed. Number one, because the state's witness hasn't testified yet. If they're going to at all, I don't know. So he'd be comparing his study to the state's study, which the jury hasn't heard anything about and may never hear anything about.
Correct, Judge.
So if he has some independent basis that makes his study relevant, that's fine, but at this point, comparing it to something that's not been put forth before the jury is not admissible. So I'm gonna ask you to, at the very least, take out the top part. As long as he can testify to this in some relevant manner, then I'm going to basically, wait and see, okay?
Thank you.
Okay,
Just one
somebody,
more, Judge.
excuse me?
Just one more slide.
Okay, which one, please?
56, please.
56. I have no idea what I'm looking at. You're gonna have to explain it to me and then tell me what the objection is,
So
please.
the studies would be the systems. So you have, again, you have Canadian guidelines, you have a study, I guess, by Dr. Home, DSM-5, and then all to the far right, it says meet that criteria, and it says yes. There's a reference at the bottom here that is another outside source. So this entire slide is impermissible hearsay.
In response, Honor, if I may, there are different standards by which fetal alcohol spectrum disorders are diagnosed. Or
Okay.
there are consistencies found with, including, as the chart shows, the Institute of Medicine and the CDC, University of Washington, Canadian guidelines, etc. In Dr. Connor's...
Well, what does that mean? I'm sorry, meet criteria.
Because those different entities have different criteria, the point is that Mr. Cruz has a fetal alcohol spectrum disorder, or he performs consistent with somebody with a fetal alcohol spectrum disorder, no matter which criteria you apply, which was of great importance to the state during deposition, because they were trying to insinuate, well, if you use a different standard, he might not qualify. The point being, no matter what criteria you use, he qualifies.
So, okay, so your position is, I gotta tell you, the way you just explained it is pretty simple. This is not simple. This is confusing. So basically, you wanna say that under 1, 2, 3, 4, 5 different standards to measure fetal alcohol, what is it called?
It's neuropsychological testing for somebody with a fetal alcohol spectrum disorder.
There's 6 different tests. These are the tests. And based upon his scores, and I'm just using words that I know, that he would meet the criteria using all 6 standards.
Yes, ma'am.
And state, you don't think that that is admissible?
I don't think the reference to all of these systems is admissible.
Yeah, I gotta tell you, I don't think this aids the testimony. This is very confusing. If he wants to testify that there's 6 different, what do you call them, systems, tests?
Diagnostic standards.
And that this is how Mr. Cruz scores, and that he would meet the criteria on all 6 systems, that's what it says at the top, that's fine. But I'm going to sustain the objection as to this particular slide.
Thank you, Judge.
Now, State, would you please take a look at, on slide number 17, the defense has indicated the specific reference in the deposition. Would you, Ms. Bashman, would you repeat?
It's, starts at the top of page 40.
Do you have that deposition handy?
I can pull it.
Might be quicker if you could just let her see your copy, please. Thank you.
Judge, I'm reading page 40 of the deposition, and I don't see, this IQ testing data from a study in the mid-90s, was one done at the University of Washington, looking at scores with fetal alcohol syndrome. He goes on to describe it, but I don't see that this was his study, and I didn't recall this being his study.
Mr. Secor, did you say this was his study? I don't remember, I'm sorry.
We're talking about number 17?
Yes, IQ scores, it says IQ distributions in the primary disabilities sample.
Yes, ma'am. This is, he specifically made this graph that's on page 17. It has been published.
So this is his work product, so to speak.
Yeah, this chart is his work product.
So then I'm going to defer ruling because it's gonna be whether or not he can show relevance in the other thresholds.
But is the data from somebody else's research and he just made a graph?
It's from the University of Washington, which is where he studied. I'm assuming that was part of the research that he was a participant in, but I can double check if you'd like me to.
That's a big assumption. If it's not his work and he's just making a chart, and it's not allowed to come in, or not allowed to, he's not allowed to rely on it.
Well, I mean, it's been published.
It doesn't matter if it's been published, that's not the issue.
Well, publication requires peer review, so, I mean, you can't just publish.
All right, I'm gonna defer on 17. I need to be able to hear what exactly it is or it isn't, okay? Sure, thank you.
So can we do a sidebar for a minute?
Sure.
May I have some time just to amend the?
Yes,
on everything?
yes.
Thank you.
Yes. We'll take is 10 minutes enough, Mr. Secor? 15 minutes?
15 would be great.
Okay, we'll take a 15-minute recess and then we're gonna rock and roll.
Study that was the subject of slides 17, 18, 19, and 20. And these graphs are taken right out of this study. They are not the product of Dr. Connor, and this article is also not peer reviewed.
Okay, hold on. Please, you said you're talking about 17, 18, 19, and 20, you said?
Yes. Well, not actually 18, that's a definition, but these graphs, this is not Dr. Connor's work, and I searched this article, I don't see him mentioned anywhere in this article. So So this is exactly the type of resource that 90.706 says should not be permitted on direct examination.
I don't think we talked about 20 before.
Yeah, we do.
Mental health problems, trouble with the law, inappropriate sexual behavior. I don't think we discussed this in court yet. Problems with employment, I feel like I would have remembered that, but maybe. Okay, so you're saying that 17, 19, and 20, you found where?
So I pulled up the articles, and these graphs are right out of the article.
What article?
This article, or this study, it's understanding the occurrence of secondary disabilities in clients with fetal alcohol syndrome and fetal alcohol effects, final report, August 1996.
Okay, Mr. Secor, the state is saying that these graphs on 17, 19, and 20 are not his work, and therefore they're objecting to him taking a graph out of a learned treatise and publishing it to the jury based on the relevant rule of evidence, 703,
706.
706.
And what I told the court is what I believe. I just need to step up for 1 second to confirm it. May I, please?
Okay. Seven oh three. 706. Thank you. What would we do without Professor Earhart? Has anyone ever taken one of his classes that he teaches? He's great.
He teaches at Florida State, I think.
No, but he teaches schools for lawyers and for
Oh.
judges periodically. And not only is he great, but he gives you his phone number. And he says you can call him anytime. And I kid you not, I was like, I'm going to try it once. And I called him and he answered the phone.
Yeah, he's great.
I mean, I was so flattered. But I guess he loves that. And most people probably think, oh, he gives out his phone number and says call him, but most people probably think, oh, you really shouldn't bother him. But I was like, well, I'm the new judge, I'm gonna bother him. He said I could, so I am.
He's close to all those guys that went to Florida State, like Chuck and Kelly Hancock.
Okay.
When he comes down here, he has dinner with him.
I've taken more than one of his classes, even though it's the same thing, because I'm always hoping that there'll be like a little something else. I just think he's very, 19 and 20, somebody wrote the numbers on mine that didn't have them printed, if you want to look at
Yeah,
my copies.
I think it's right. At 17 is the IQ distributions, correct?
It's like a red and blue graph,
ma'am.
okay, yes,
And then 19 is characteristic profile and FASD IQ adaptive function disconnect.
correct,
And 20 is cognitive dysfunction plus environmental influences, correct?
correct.
Okay. For clarification, these three graphs were created at the University of Washington based on research that Dr. Connor was involved in. He was a postdoctoral fellow at the University of Washington in their fetal alcohol program at the time. So he participated in the research that generated this data. He was not an author of the actual article, but he was conducting the research and compiling the data. I stand corrected regarding whether he was the author of the article, because he was a postdoctoral fellow at the time.
Judge, this is still very much someone else's research. You basically was an intern at the time.
Okay.
Well, I know what you're gonna say, a
Thank you.
fellow is not an intern.
I mean, I don't.
But
mean
they're
to be
not a
literally-
resident either, or not a resident, attending,
Right.
right? Okay. He can incorporate these studies into the basis of his opinion, like any other expert. But as far as using these as slides, because I thought what you were saying was not only did he author these particular studies, but that he also, I'm trying to think of the word, adapted them specifically to Mr. Cruz's situation. In other words, made them specific, more specific for this particular case. But I think basically these are taking drafts out of a learned treatise and publishing those to the jury, I think falls under the 9706 as substantive evidence, as putting them forth as substantive evidence, which is not admissible. That is not to say he can't testify to these things based upon his training and experience and research. But I'm going to sustain the state's objection as far as using those particular slides.
Thank you, Judge.
Thank you.
17, 19, and 20.
So 18 I already excluded.
Yes, ma'am.
So 17, 18, 19, and 20, if you want to take a look, Mr. Secor, if it's easier for you,
No, I believe I have the right ones.
compare these to what you have.
Yeah.
I know you have a lot of slides there, so,
So it's that one, the adaptive functioning one, this one, and that one.
correct.
Okay,
I was looking as you were paging through them.
thank you.
Intuitive. It's important. I'm bringing it up for you. Like if you say, I insinuated, I intuited it. I used my intuition to figure it out. I intuited it. It is. To intuit, but intuit in the past tense, intuited. Yes? Come on. Was reminded we don't have Zoom set up?
No, it's not ready yet till we.
What? So you all set Zoom up on your end, I'm being told?
No, ma'am, we thought we were using the court Dr. Connor's been in the waiting room since 9:20?
He's in the waiting room.
So we're on the webinar, so we have to wait for you to put it on.
Well, what, just tell me what to do.
I'll set it up now.
I guess since there's a webinar, I don't know why this is, you see, Zoom is always, because we have a webinar, we have to do a separate thing. And we're doing that now?
Yes, Judge.
Which means if Judge Porter is doing the FJ docket on Zoom, she gets kicked off every time we go on, or Zoom ends. Because she does my docket.
I can start a Zoom if need be.
Ian, do you want, I don't know how it works, except that it doesn't. Usually. Okay, all right.
Your Honor,
Yes,
we came to an agreement regarding Zoom issues that
Okay.
we discussed a couple weeks ago.
that's good because the Supreme Court opinion doesn't go into effect until October 1st. Did you all see that?
I did not.
Okay, never mind.
At any rate, we've signed the agreement. I've turned it over to the defense. We'd like to get it just signed before we begin this Zoom.
Sure. Who has it?
The defense, I'm just waiting for them to sign it so we can present it to the court.
Okay.
Is that Mr. Paul?
Yes, it is.
To intuit, to understand or work by insight. Intuited is the past tense. You didn't believe me. That's from the Oxford Dictionary. All right, I'm signing this agreement.
Someone want to test with me?
Judge, would you like to test with him?
Sure. Is it Dr. Connor? Paul Connor?
Yes.
Good morning, sir. This is Judge Shear, and we're just doing a test to see if you can hear me.
I can hear you just fine, Your Honor.
Okay, sir, I'm just going to remind you of a few things because we've had other Zoom testimony. And I just want to remind you that please, just as if you were testifying in court, if you have a cell phone, please turn it off. Things like that. We've mainly had people with cell phones ringing and I forget to tell them, and I think sometimes when people are in their office, they don't think of it. So just to let you know. Also, I have your Washington driver's license here, which I will use to identify you, to swear you in. The only other thing I need to know is we're going to have the lawyers from both sides ask you a question and see if you can hear, okay?
Okay.
State, you want to go ahead and do a test?
Can you hear me, Dr. Connor?
You're muffled, but I can hear you.
How about now?
Nope, much worse.
Now?
Yes.
Okay. Thank you.
Well, you know what? Both sides will come to the podium, right?
Right.
So, Mr. Secord, do you want to test from the podium, please?
Yes, ma'am.
And then also, Dr. Connor, I need to be able to make sure that you can see the defendant, Nikolas Cruz, and that he can see and hear you. Mr. Cruz, would you raise your hand, please?
I see him.
You see him? Okay, and Mr.
Yes.
Cruz, can can you see Dr. Connor?
Yes, ma'am.
And Mr. Cruz, can you hear Dr. Connor?
Yes, ma'am.
Okay, if Mr. Cruz, at any time, if you cannot see or hear him, please let your lawyer know and they'll let me know. The same thing with Dr. Connor, okay? Also, Dr. Connor, I'm not sure how often you've testified, but when there's an objection, if you would please just stop talking until I can rule on it. If sometimes during Zoom, the witness doesn't hear that somebody says objection, so what I will do is I'll say, sir, give me a minute or something to that effect. Wait just a second, please. And at that time, if you would just please stop talking until I can rule, and then that's it.
Sounds good.
I'm just going over things that have been issues with other witnesses on Zoom in this trial. That's the only reason.
Judge, may I just bring up one last thing?
Okay.
As a consequence of your ruling on 17, 19, and 20, I think it was,
Okay.
there is one of those same graphs appears on page 47, which previously, Your Honor, had ruled was admissible. And I just don't want to run afoul of what Your Honor just ruled.
Is this the type of graph that we were under the impression that your witness had compiled either in the past or in the present time for
Right,
this case, for his testimony?
He participated in the research that was compiled for the data represented in the graph, but he did not make the blue graph on page 47. He did make the graph next to it, which represents Nick's scoring. Does that make sense?
Yes, so the graph to the right of the blue rectangle on slide 47 was made by your witness in preparation for his testimony, and he has the blue graph just to be able to compare what he made to the actual study.
That's correct.
State?
Judge, I don't have a problem with the graph on the right staying, but as far as the graph on the left, that should be removed.
Okay, for demonstrative purposes, in order for the jury to get anything out of this, if they can't see the I don't know what you would call it, the standard graph, I don't know how they would make heads or tails out of the graph that was compiled by the witness. So what I'm going to say is this, Mr. Secor, do not make the blue rectangle a feature. In other words, it's there for the jury to be able to understand the graph that was made for Mr. Cruz for this trial,
Yes, ma'am.
if that makes sense. Okay, so the state's objection is overruled. Yeah, that's it. Okay, sir, I'm not going to swear you in until the jury comes in. That's why I haven't done that yet. Yes, Dr. Connor? Did you hear me? So
Yes.
I think you're on mute. Okay. When the jury comes in, I'm going to swear you in and ask you to state your name as if we've just met for the first time, okay?
Okay.
Thank you.
Now approach the podium.
Yes.
Judge, is it okay that after lunch we bring you the copy without the redactions, just so we can make it part of the full file for appeal?
Absolutely.
Your Honor, is there anything?
Hold on 1 second, please. 1 second. Yes?
Your Honor, consistent with this court's ruling regarding the hearsay statement, the double hearsay statement that Dr. Connor relied upon in making his slides on slides 25 and 26, I would like the court to do whatever instruction it seems fit to let the witness know not to refer to the report of the conversation
Okay.
that the witness, that the deceased declarant had with Dr. Heather Holmes, please.
Okay, Dr. Connor. Can you hear me, sir?
I can.
Have Secor?
Yes, ma'am. Dr. Connor, can you hear me?
I can.
The state and the judge want to make sure, man, my voice sounds awfully loud up here, that you are not going to make any reference to the actual words said by Brenda Woodard to Dr. Heather Holmes. You understand that, right?
That's correct.
Okay.
In other words, sir, if if the information regarding the biological mother using crack cocaine and alcohol during her pregnancy was a fact that was made known to you, and you used that fact as a basis for your opinion, that's fine, you can testify to that. However, any of the details about the quotations, I kept drinking to calm my nerves, it was stressful, those things you cannot testify to, okay?
So, sorry. So I can testify to the fact that I am aware that she was interviewed by Dr. Holmes and that Dr. Holmes, and that she acknowledged using alcohol and cocaine during pregnancy, correct?
Actually, no. I'm glad I brought it up because it is a little confusing. So, forget that interview. Her friend has already told the court and the jury that she knew the biological mother, and she knew the biological mother when she was pregnant, and that she used crack cocaine and alcohol during pregnancy. And those were facts that have been testified to that are before the jury in evidence. So those are the only facts that you can testify to, that you're aware that the biological mother used crack cocaine and alcohol during pregnancy. But as far as her interview, and as far as anything other than the fact that she used crack cocaine and alcohol during pregnancy, which really, the fact that she may have used them while sleeping in a car and all those other things, I assume those don't affect your opinion.
What about the information of her use while she was in the records?
Excuse me?
There was information about her use of alcohol in her records. Are those free for me to discuss?
I'm not sure what he's talking
Yeah, there are birth records where she acknowledges abusing alcohol while she was pregnant, and that's part of his presentation.
And those are in evidence.
Yes, ma'am. And there's a slide in his slide deck that points that out, and there he's reviewed those records.
But have those been testified to? I'm sorry, I don't remember.
I can't remember.
Yeah. Testified to by Dr. Scully, the adoption records and birth records.
Dr. Scully has testified to the adoption records and the birth records. Scully Danziger, is that right?
I apologize, I just don't remember.
She was a pharmacologist, if that helps.
And so his adoption records were put in through her, and there's a note in the adoption records that the mother admits to using alcohol and drugs during pregnancy?
Adoption records and the birth records, actually at the hospital.
And those are in evidence.
I believe so.
Come on, guys, I need to be able to give this witness a clear picture of what he's able to testify to. I don't know.
Well, I can tell you that he has reviewed them, and they certainly will be in evidence, which is consistent with the case that we were discussing earlier, that an expert may testify to information that either is in evidence or will be in evidence.
State, are you agreeing to that? I don't remember.
If they come into evidence, Your Honor, but, they have to come into evidence in order for the witness to testify about it. And just to be crystal clear, so that this witness understands, the witness cannot testify as to the interview that Dr. Heather Holmes conducted of Brenda Woodard, and cannot testify as to anything he learned or opinion he reached from that interview. Because it's double hearsay.
I think he understands that. As far as records, birth records and adoption records, there was a lot of hearsay and witnesses testifying to certain things, and I just don't remember. So can we please make absolutely sure that what he's being a diligent witness and he's asking me, can I talk about these things? I don't know. If they're not in evidence yet, he cannot.
If I may, Judge, because I did the questioning on
Okay.
Dr. Scully. So it was, I believe, in the discussion of the negative meconium test, and I was asking her about any evidence that she found in the records that would show that the meconium test
So
was
his
not.
birth records were not introduced.
They
She
were
testified,
no.
the state didn't object, she testified to hearsay, and it's in front of the jury. So do you have any objection to him testifying to the birth records? You see what I'm saying? There was a lot of perhaps objectionable questions asked, but that were not objected to.
Can I just ask a point of question? Are Dr. Marcus's records in?
Yes.
Yes.
Yeah, well, that contains the birth records, that the entire,
Well, then there you go.
And then, Judge, we can also, may I approach the evidence?
Sure.
We can, we provided this to the state with the certificate of authenticity. We can move in all of the adoption records for Nikolas Cruz. There is a caveat. There is some information that has to be redacted pursuant to a
Okay,
court
but
order.
if the adoption records and the birth records are already in evidence, that's all he needs to know. He just wants to be conscientious.
No, I understand, but I don't believe that the adoption records are in. Dr. Marcus's records included the birth records. So we can move in the adoption records now. We have a certificate. And then that would take care of all of it.
State,
no objection.
okay? Dr. Connor, are you following all of that?
Not completely.
Okay, what's in the adoption records and the birth records, you can testify. First of all, you can give your opinion based upon the knowledge that you have without saying where you got the knowledge from. Do you see what I'm saying? But if you use the birth records and the adoption records as a basis for your opinion, they are in evidence, you can testify to them. The fact that the mother was using drugs and alcohol during her pregnancy is a fact that's in evidence, has been testified to. You may testify to that as well. However,
Very well.
any conversation between the biological mother and Dr. Heather Holmes, you may not talk about.
Very well.
Okay?
Judge, may I just press the-
Hold on just a second. And if you have, yes. And if you have any questions, because I understand we're asking you to testify here in a vacuum, just say, Judge, can I answer that? And I'm happy to help, okay?
Okay.
I know it's gotten a little,
Dr. Connor, because it needs to point some things out on the screen, is going to be controlling the PowerPoint. And so Mr. Ian just asked me to ask Dr. Connor to test that out to make sure it works. Is that okay with Your Honor?
sure.
Let's see. Oops. Hang on a moment, please. Okay, are you able to see the screen?
Yes, sir.
Okay, and let me start the slide deck so that we can make sure that works too. Oh, that puts it way over there. Okay, interesting. Are you seeing the full screenshot, or are you seeing with the file name and stuff like that around it?
Yeah, I'm seeing the main screen, and then on the left-hand side of the screen is the enumerated slides that are forthcoming.
Okay, so it does or it does not have the like home, insert, design, transitions, that sort of thing.
It just
Okay. Here's the question. Can you see my mouse moving?
Yes, sir.
You can.
Yes, sir.
Can you see my mouse moving?
No, sir.
Nope. Okay. I'm going to stop sharing. It's not doing the right thing. Escape. Let's try this. Screen share. That screen. Dang it. Problem that I'm running into is when I go into screen share mode, it does not show the full slides on that screen. So let's try it this way. Let's do the full screen now. Why are you putting it over there? I don't want it. I have it now. Let's try this. Okay, now do you see it as a full screen?
Yes, sir.
Okay, so no file or anything like that around it, correct?
Correct.
Okay, great. That's sorted then.
Judge, do we want to check the jurors' screens before they come in?
Great idea.
Doc, will you restart the PowerPoint, please?
But I thought you saw.
Okay, you are very
We-
quiet.
We checked it.
Mr. Secor?
We saw it when it was up. Right? Okay, all right.
And also, I cannot see Mr. Cruz at this point. I can only see Judge Scherer.
Can you see him now, Doc?
Our
Yes.
Our IT guy, our IT professional, Ian, will put me on when I'm swearing you in or when I'm talking, but otherwise you'll be able to see
Okay.
all of the lawyers. But thank you for bringing that to my attention.
Okay.
What is the defense strategy and the members?
But I can give you what's more.
You don't have it? No, I have one.
I'm just gonna fix it to make it easier for board council, but it's the same, it'll be the same mark.
But I need to know, I need to put it on the record because I received it. So where are the IDs?
So I have 3C.
All right, 3C will be received without objection as defense 84.
3D, because there's separated.
How many different things? No, just tell me.
3 different ones, so it'll be
3C, 3D, and 3E. All right, 3C for identification is received as 84, 3D, 85, and 3E, 86. All right, lawyers, we're gonna go till 1 o'clock, and then we'll take a lunch break, but we need to get these jurors in here and get moving.
Yes, ma'am.
So please bring in jury, thank you.
Jurors are in, jury?
Okay, the jurors are present. Ladies and gentlemen, one of the most stressful jobs for the judge is accommodating or not the jury. And I just want to say that you all are so patient. And I really, really appreciate it because I get very stressed when we keep you waiting. It's nobody's fault. Blame it on me if you need to blame anyone. Sometimes things come up. We think it's gonna just take a few minutes. As you know, you were brought out into the hallway and then back and forth. And there's just, sometimes we cannot anticipate the length of time that certain legal issues take for us to hash out. I assure you, if I knew we weren't gonna be starting until after 11:30, I would not have had you here at 9 a.m. So I apologize, but thank you very, very much for your patience. You have no idea how much less stress it is for me because you all are so great, so thank you. Okay, Dr. Connor, can you hear me?
Yes, I can.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down. Please state your full name for the record.
My name is Paul David Connor. Last name is spelled Connor.
And for the record, I have identified you in order to swear you in by your Washington driver's license. Mr. Secor, when you're ready, you may inquire.
Thank you, ma'am.
Thank you.
Good morning, Dr. Connor.
Good morning.
If you just tell the jury, please, what your current occupation is.
I am a clinical neuropsychologist in private practice in Des Moines, Washington.
And please describe to us your educational background.
I'm sorry, you're a little bit quiet. I apologize.
Please describe to us your educational background.
Okay. I received a Bachelor of Science from the University of Washington in 1988. Received a PhD in clinical psychology with a specialization in neuropsychology from Brigham Young University in 1995. As part of that training, I did a one-year internship at Henry Ford Health System in Detroit, Michigan, also specializing in neuropsychology. Then I served as a postdoctoral fellow at the University of Washington's Fetal Alcohol and Drug Unit, doing research on individuals with FASDs.
And as a postdoctoral fellow, what was your specialization?
Again, it was in neuropsychology
Okay.
and fetal alcohol spectrum disorders.
And any teaching positions that you've had?
Once I finished with the postdoctoral fellowship, I was an acting instructor, and then moved through the faculty ranks to the level of assistant professor. That was purely in a research capacity. I was not doing, I was not giving quarter-long classes. That was in the research track.
All right. And what if you have you had been part of or published any journal articles or studies that you've been part of?
Yes.
And can you describe what those have been primarily based on?
Predominantly, they have related to the neuropsychological and mental health and other aspects of research on individuals with FASD.
Okay. And when you say FASD, what does that stand for?
Yes, fetal alcohol spectrum disorders.
Okay. And have you ever testified as an expert in these fields?
Yes, I have.
And do you have any idea approximately how many times?
About close to 50 at this point.
And in what states do you know?
Washington, Oregon, California, Arizona, Nevada, Texas, Florida, several other states, Tennessee, the Carolinas, and a number of other states that I'm just not thinking of off the top of my head.
Okay. And when you have testified, have you testified before on behalf of a person who is charged with a crime?
I have.
Okay. And when I say testified on behalf, I just mean you were called by the lawyers representing that person. Is that right?
Yes.
Okay.
I've also been called by the prosecution.
Okay. And have you done any, in terms of your work with the prosecution, describe to us what that has been?
Typically, that involves assessing the victim in a case. I also am called by the state in cases where I am doing assessments of usually parents for the Child Protective Services. I'm contracted to do assessments of their parents. And so I'm doing these assessments, and from time to time I'm being called because the case goes to a termination hearing. So usually when I'm called by the prosecution in those cases.
Okay. And so am I right that if you're testifying that that's considered a forensic case, is that correct?
Yeah, I mean, especially with the CPS cases, those are initially a clinical case. They're trying to find out how to work with the parents, things like that. But eventually, if it does go to termination hearing, then it does move into a forensic side.
Okay. And when you're working forensically, what is your hourly rate?
At this point, it is $350 an hour, $350 an hour. When I became involved in this case, it was at $325 an hour.
Okay. And do you have an approximation of the number of hours you put into this case?
At this point, approximately 145 hours.
Okay. If you would describe it to us, please, a little bit about what you, I know you described to us the forensic aspect of your work, but what else does your private practice entail?
Yeah, the predominance of my work is clinical in private practice, where I see people from a wide range of potential neurological conditions, ages 16 through end of life, and so assessing ADHD, learning disabilities, traumatic brain injuries, strokes, seizures, dementias. But one of my specialty areas is in fetal alcohol spectrum disorders. So I get a number of cases that involve that clinically.
And are you aware of other neuropsychologists who are specializing in fetal alcohol spectrum disorders in the United States?
Unfortunately, in the United States, there are very few. In the adult realm, there are more that work with children.
And what, for purposes of this case, Mr. Cruz's case, what was the referral question that was asked of you from the defense?
I was asked to conduct a neuropsychological evaluation to determine if his current cognitive functioning is consistent with diagnostic guidelines for an FASD.
Okay. Now, I believe that you have created a PowerPoint to aid in your testimony and to provide the jury some visual aids or demonstratives. Is that correct?
That's correct.
And I was hoping that you could start off by describing to us what is fetal alcohol spectrum disorder.
Well, fetal alcohol spectrum disorder itself, it's not actually a diagnosis. It is an umbrella term. And so it's just indicating the overarching term of fetal alcohol spectrum disorders is indicating that there are several specific diagnoses underneath that umbrella. There are medical side diagnoses such as fetal alcohol syndrome, which is where an individual has all the physical features, facial features, small eyes, thin upper lip, smooth philtrum, and short stature, as well as cognitive impairments. There's partial fetal alcohol syndrome where they have some of the physical features, but not all of them. But again, they still have the significant cognitive impairments. And then there's alcohol-related neurodevelopmental disorder, or ARND. And that is a diagnosis where the individual does not have the physical features that you see in fetal alcohol syndrome, but they have the same cognitive impairments. Those are the medical side diagnoses. Beginning in 2013, the Diagnostic and Statistical Manual that's produced by the American Psychiatric Association came out with a diagnosis that's on the mental health side that relates to fetal alcohol spectrum disorders, and that's neurodevelopmental disorder associated with prenatal alcohol exposure.
Okay. And so the neurodevelopmental disorder associated with prenatal alcohol exposure being a psychiatric diagnosis, that would be your purview, is that correct?
Yeah, that's in my area.
Okay. But based on your knowledge of what alcohol-related neurodevelopmental disorder is, what would be the difference between a person who has NDPAE versus a person who has ARND?
There is no difference. They're essentially synonymous terms. The only difference to the medical side is that it is focusing on the presence or absence of physical features, while the NDPAE is focusing on the cognitive behavioral side of things. So both of them have that component built into them.
Okay, and just one last point on this. At the bottom, you talk about fetal alcohol effects, and
Right.
Is that term still used?
It's not used anymore. Back in 1973 was when fetal alcohol syndrome, the term was coined. In 1978, they coined the term fetal alcohol effects for all the individuals who have some or none of the physical features of FAS, but they have the same cognitive problems. That term was phased out in 1994 when the Institute of Medicine then started using the terms partial fetal alcohol syndrome and ARND. So people that would have in the past been diagnosed with fetal alcohol effects would now be diagnosed with partial fetal alcohol syndrome or ARND.
Okay. And Before we move on, I was just hoping that you could describe to the jury the extent to which alcohol has an impact on a growing fetus versus other types of substances of abuse or illegal drugs.
Yeah, I mean, use of any substances in pregnancy can have an impact on the fetus. And we do know that nicotine, cocaine, heroin, all of those can have an impact, at least on the modulation of how the fetus develops. Alcohol, in the research that's been done over now about 50 years, has consistently found very strong impacts on the fetus in multiple areas that were assessed, both from the physical perspective and from the neurological perspective and from the neuropsychological and behavioral perspective.
And so, do I understand you correctly that alcohol, in terms of the effect on the fetus, is worse than those other drugs that you mentioned?
Yes, the research has been very consistently indicating that.
Okay. And would you please tell us what it means for a substance to be a teratogen?
Right. So like I said, there are all those other substances there like nicotine or heroin or cocaine even that can have an impact, but they're not what are called teratogens. A teratogenic substance is something that will kill cells. So let's say that you put a nerve cell into a petri dish and you put alcohol in it. It will kill that cell. That's what a teratogen does. So that's the primary difference, and alcohol does do that.
Okay.
And it's a well-known teratogen.
And in terms of how it gets to a fetus from the mother, can you describe that?
Mm-hmm. Yeah, the placenta offers no protection. Alcohol will freely pass through the placenta. So within a couple of minutes of mom drinking, consuming alcohol, the baby has an equal proportion of alcohol within its system. Unfortunately, early in pregnancy, the fetus has no liver that's functioning. So it is depending on mom to filter out the alcohol. So the alcohol gets into the system, the fetus's system very quickly, and it takes a while for it to get out of the system because it's relying on mom to do that.
And based on your experience and research that you've done, is there a time frame within which you know the fetus is affected by alcohol?
In animal studies, we found that as little as 12 hours after exposure, we can see dead cells in the brains or in the developing fetus of mice.
Okay. And will you go to the next slide? I think that there's a visual there. Will you describe what this is to the jury, please?
Yeah, so like I said, they administered alcohol to a pregnant mouse dam mother. And then 12 hours later, they sacrificed the fetus. They used a particular stain that is taken up by cells that are dying or dead. And then they were looking for those cells. Those cells would turn black if they were dead cells. And you notice that this mouse fetus that was exposed to alcohol has a lot of dead cells. And if you look on the right side, those dead cells tend to congregate in the front part of the developing mouse fetus. That part of the mouse is what goes on to become the brain and the face.
Okay. Now, can you describe to us I know that you said that alcohol will kill cells, but what other effects does alcohol have on the cells in a developing fetus?
Yeah, so alcohol has the direct toxic effect, but also as alcohol is being metabolized through the liver, the first metabolite of it is called acetaldehyde. That also is a teratogenic substance. So even while the alcohol is being processed and broken down, the substances that it's producing in that process are also teratogenic and can cause direct impact on the fetus. Alcohol will affect indirectly, it can affect the umbilical cord and impair blood flow from the mother to the fetus through the placenta. And so you can get what we call hypoxic effects, so lack of oxygen or insufficient oxygen. So you can get these indirect effects just from the reduced blood flow through the umbilical cord. And alcohol has an impact on all stages of cell development throughout gestation. So initially, it impacts the generation of cells. It's killing the cells as they're being formed. It then also can impact when cells are replicating or proliferating. They're making more copies of themselves. It can kill those cells. The way that most of the cells are made, and you can kind of see that in the mouse slide, is that they tend to clump in a kind of more central area, and then as they proliferate, then they start moving to the place in the brain where they need to be in the full, complete baby as it's born. And alcohol can stop that process of migration, the movement of those cells. And some of the first autopsy studies that were done actually found what are called heterotopias, or clumps of cells in places where they shouldn't be, right in the middle of white matter, which is basically those are just the phone lines. So the phone lines should be there, but the clump of cells themselves shouldn't be. As the cells get to the places in the brain where they need to be in the final form, they start needing to make connections to different parts of the brain. Alcohol can impact that. It can kill the nerve projections as they're going to other parts of the brain. And then the last part of that process, once we've made those connections between different parts of the brain, we're making a lot of connections that we don't necessarily need. And we need to have a much more efficient connection pattern in order for the brain to function efficiently. And so one of the normal processes of development is that we have what's called pruning or apoptosis, where cells and connections are killed off. They have to be killed off. Because if you think about it, if you got a cell that is here and it's talking to a cell that's here, which it's supposed to do, that's great. Should be exactly doing that. But if you also have a projection that goes from here to the front of the head where it's not supposed to be, you're giving information to this part of the head that it doesn't know how to deal with. And so if you think about it kind of from an electrical perspective, it kind of short circuits the system. You don't want that. But alcohol can stop that process so that you still have that connection to the wrong part of the brain.
You mentioned that alcohol, when it's broken down by the mother's system, that it becomes, I think you said acetaldehyde, is that correct?
Yes.
And at the point you made, that also is a teratogen, right?
Correct.
And of the other substances that you talked about, other drugs of abuse or illegal drugs, do they also become acetaldehyde when broken down by the mother?
No.
Thank you. I believe if you go to the next slide, Doctor, it's just an example of what can result from prenatal alcohol exposure. If you could describe that to us.
Yeah, I mean, on the most extreme end, it can cause death, either spontaneous miscarriage or failure to thrive soon after birth. It can lead to those physical malformations, the facial features that we see in individuals with FAS and partial FAS. It could lead to growth deficiencies. Individuals with FASD often tend to be quite small, short-statured, often are underweight, at least as children. And then probably the area that's germane to what I do, it causes functional deficits.
And the functional deficits, as a consequence of alcohol exposure, the functional deficits are a consequence of what?
The impacts that the alcohol has on the developing brain of the fetus.
Okay. And the developing brain, that system within the body, that's the central nervous system, is that correct?
Yes.
Okay. And throughout the course of a woman's pregnancy, is there a time when the central nervous system is particularly vulnerable to the effects of alcohol?
No, it's all throughout pregnancy. from the beginning to the end where the brain and the CNS is vulnerable.
Okay. I think I'd like to ask you now to describe to the jury the criteria that you use when you're assessing somebody, starting with the Institute of Medicine, if you would.
Okay. Yes, the Institute of Medicine was a group that was called together by a mandate from the federal government to try to develop, I should say, criteria for the diagnosis of, at the time it wasn't called fetal alcohol spectrum disorders because that hadn't been coined yet. This was in 1994, but for FAS and FAE. As part of that, they renamed the diagnoses to fetal alcohol syndrome, partial fetal alcohol syndrome, ARND. There's also another condition called alcohol-related birth defects, which are basically impacts physically, skeletal, heart conditions, liver conditions, things like that, but we don't focus on that as much, especially when it comes to the neuropsychological side of things. But the criteria that relate to the cognitive impacts, the things that are part of what I do for my evaluations through the IOM, was looking for evidence of some sort of CNS abnormalities. It could be structural changes to the brain, decreased size of the brain. It could be kind of neurological signs like motor coordination problems, eye-hand coordination problems, things like that. And then it talks about an evidence of a complex pattern of behavior or cognitive abnormalities that are inconsistent with developmental level, can't be explained by familial background or environment alone. And then it lists a number of possible areas where a person could have impairments. It's not an exhaustive list, and it's not a list that says you have to have all of these. So it talks about, impulse control, school performance, learning disabilities, social perception troubles, language, expressive and receptive, difficulties with abstraction, math, memory, attention, and executive functions like judgment.
And let me just real quickly ask you, based on what's on the screen now, the IOM guidelines, the reason why the criteria A, B, and C are not listed here.
Yeah, A, B, and C have to do with alcohol exposure, the facial features, and growth deficiencies.
Okay.
Again, those are the physical sides are not part of my usual purview.
Okay. And just for clarification, in D, whenever it says CNS, that means what?
Central nervous system,
Okay.
basically the brain.
All right. Now, would you explain to us how you use those guidelines when you are making your assessment?
Yeah, so I use the IOM as the framework for our assessment, for the assessments that I'm involved in. But I'm not overly happy with the terminology of complex pattern of behavior of or cognitive abnormalities. It's rather nonspecific. In 2004, the Centers for Disease Control and Prevention, again mandated by the federal government, sat down to try and clarify some of the issues related to the diagnostic criteria. And again, this is just focusing on the neuropsychological or cognitive side of things. They also made comments about the physical side of things. But they, that as part of their the outcome, they set pretty specific criteria that can be replicated very frequently. So they have to have either an IQ that is 2 standard deviations below the mean. That means that the person's IQ score is in the intellectually disabled range, or back in the day, used to be called mentally retarded range. Or they're demonstrating deficits in 3 domains, 3 areas of functioning that are at least 1 standard deviation below the mean. That means that they are performing worse than at least 84% of the population within those domains. And they go on to say what domains they, some of the example domains, again, it was not designed to be an exclusive or an inclusive list, it was designed to be an example of these are the domains that we often see. And you don't have to have every single domain in order for the diagnosis. You just have to have deficits in 3 domains. So cognitive or developmental issues such as academics, also discrepancies where there's big differences between scores, like on IQ or academics. Those are also counted as an indication of the developmental delay. Executive function impairments, planning, problem solving, learning from your mistakes, coming up with new ideas. That's all what kind of executive functioning is, not getting stuck on an idea. Motor coordination, attention, hyperactivity, kind of your classic ADHD sorts of behaviors, social skills, then again, language, memory, things like that are also very commonly were ones that they identified as being common issues.
And just because I think this is going to come up occasionally during your testimony, can you just sort of help us understand the concept of a standard deviation, what that means?
Yeah, so a score, when you take a score, you get a number, a single number. But that's not always the actual number. It can range a bit. So there's some variability there. So when you're looking at the standard scores for a test, let's say a score, an IQ score, on average, an IQ score in the general population is about 100. But that ranges. So about 68% of the population are somewhere between -1 standard deviation and +1 standard deviation. That's kind of the normal range, down to low average range. But there's that range that we typically see that's 1 standard deviation above and 1 standard deviation below the average score.
So in IQ testing, how many points is 1 standard deviation?
That would be a range from 85 to 115. So it's a 15-point difference.
So 1 standard deviation in IQ testing is 15 points. Is that correct?
Correct. Yes.
Is the standard deviation in all types of testing also 15 points?
No. Each different standard score has its own standard deviation, own range. So there's another type of score that's commonly used in neuropsychology called a T-score. And that has an average of 50 and a standard deviation of 10. There's another type of score called a scaled score, and that has an average of 10 and a range of 3, or standard deviation of 3, sorry. And then there's still another one called a Z-score, and that has an average of 0 and a standard deviation of 1.
Okay. All right. If you can move on and describe to us how you use the Institute of Medicine and the CDC together.
Right. So like I said, I'm not as happy with how IOM has this complex pattern that's not really well defined. CDC brings to the table a much more structured criteria, must have deficits at least 1 standard deviation in at least 3 domains. So it's much more structured. That means that you can apply it reliably across all subjects that you see, all patients that you see. So I see one person and I find that they have 2 deficits in 2 domains. They wouldn't qualify for the diagnosis of an FASD. But if I see a person that has 8 domains, they would qualify. And I can reliably use that same cutoff for every patient that I see. And having the requirement that there be multiple domains of impairment satisfies the IOM's concept of the complex pattern.
Okay. Next, I was going to ask you if you could just describe to us generally what a neurodevelopmental disorder is.
Yeah, this is from the DSM, the Diagnostic and Statistical Manual that was published by the American Psychiatric Association. They talk about neurodevelopmental disorders as conditions that start in the developmental period in children. They manifest early, and we see deficits in development, deficits in brain processing that impact personal, social, academic, occupational functioning. So it's not enough that they are just doing poorly, it's got to actually impact them in the real world. And so that's why you need both the symptoms and the impact, the impaired functioning in day-to-day life.
And based on your experience and knowledge and education, are neurodevelopmental disorders, are they caused by a specific thing?
They can be caused by many different things. Neurodevelopmental disorders is again a grouping. So intellectual disability falls within the neurodevelopmental disorder range, as does learning disabilities, as does ADHD. They can be caused by a lot of different reasons that we may not ever know.
Okay. Is there a recognized neurodevelopmental disorder that's considered to be caused by in utero alcohol exposure to a fetus?
Yeah, one of the diagnoses in the neurodevelopmental disorders section is called other specified neurodevelopmental disorders. So this is basically, they don't necessarily meet criteria for intellectual disability. They don't necessarily meet criteria for ADHD. There's something different about them, but they are definitely demonstrating a neurodevelopmental disorder. The only example of that type of disorder that it poses or that it gives in the DSM is neurodevelopmental disorder associated with prenatal alcohol exposure. So neurodevelopmental disorder that's associated with prenatal alcohol exposure, characterized by a range of developmental disabilities following exposure to alcohol in utero.
And am I right that this description of it here that's in the DSM is sort of similar to what you said about the IOM's criteria? It's not particularly specific. Is that right?
No, unfortunately it's not.
And can you apply the CDC criteria to this the same way you did to the Institute of Medicine?
Yes, very much so. Again, it's being relatively, non-specific, but the same issues of creating a much more structured and reliably reproducible set of cut points, essentially, where you're having to find deficits in multiple domains that are impacting their functioning, is very much in keeping with a way of operationalizing the neurodevelopmental disorder associated with prenatal alcohol exposure.
And before we move on, can you just tell us what the F88 stands for on that slide?
F88 is a billing code. It's a diagnosis code, honestly. So if you have an individual that has an other specified neurodevelopmental disorder and you categorize it as the neurodevelopmental disorder associated with prenatal alcohol exposure, you cite that code. And it is a recognized diagnosis, and it's one that can be used for billing purposes.
Okay. Now, I would like you to describe to the jury the difference between that neurodevelopmental disorder associated with prenatal alcohol exposure versus what also appears in the DSM, neurobehavioral disorder associated with prenatal alcohol exposure.
Yeah, so this neurodevelopmental disorder associated with prenatal alcohol exposure shows up in the front sections of the DSM. These are the diagnosis sections, the actual diagnoses. In a back section of the DSM-5 and DSM-5-TR, it has a section of conditions in need of further study. And in that section, there is the term neurobehavioral disorder associated with prenatal alcohol exposure. And so they've proposed a series of guidelines, diagnostic guidelines that can be used to identify this neurobehavioral disorder.
And you appear to use the same acronym. Is that correct? NDPAE?
They do.
Okay. Now, based on your expertise, even though they both have the same acronym, but is neurodevelopmental disorder associated with prenatal alcohol exposure the same thing as neurobehavioral disorder associated with prenatal alcohol exposure?
Likely. I mean, right now in the DSM for the diagnosis, it does say neurodevelopmental disorder. So that's what I use for the diagnosis. but they're trying to get at the same sort of thing, the impact of prenatal exposure on offspring throughout their lives.
Okay. Now, you mentioned one thing that I just want to make sure we're on the same page. You mentioned the DSM-5 and the DSM-5 TR. What's TR?
TR is for text revision. So the DSM has editions up through now 5. DSM-5 was released in 2013. Usually as part of kind of a mid-cycle refresh, shall we say, they release a second version of the DSM-5, and it's called the text revision. And so what they do in that is that they talk about research that's been done in the ensuing several years. Sorry, this was released in 2022, just a few months ago. So it talks about the research that's been done in over the years since the DSM-5 was published. And so it adds information, text, to like associated features, treatment modalities, and things like that. The DSM-5 TR does not change the diagnostic criteria. That's not part of its mandate. It's designed to look at what the research has been over a few years and kind of that are associated with the diagnoses, but not the actual criteria.
So between publication of the DSM-5 in 2013 and the DSM-5 TR in 2022, is there any change whatsoever to neurodevelopmental disorder associated with prenatal alcohol exposure or neurobehavioral disorder associated with prenatal alcohol exposure?
No.
All right. Can you describe to us what the diagnostic features are for neurobehavioral disorder associated with prenatal alcohol exposure?
Yeah, so again, impairment in cognitive, behavioral, adaptive functioning with prenatal exposure. You can use multiple different sources to find that information, whether it be records, prior evaluations, et cetera. But we're looking for neurocognitive impairments in self-regulation. So mood dysregulation, being really unstable with your moods and up and down, things like that. Attention deficits, impulse control problems, things like that. And then also impairments in adaptive functioning, communication, social interaction, social communication, daily living sorts of skills, being able to keep yourself clean, managing the household, things like that. And also it talks about motor skills. So those are kind of the 3 primary areas that it talks about for areas of impairment that you're looking for.
And I know you gave some examples of neurocognitive impairments there, but can you just sort of help me when I hear the word neurocognitive? What should I be thinking about?
Yeah, again, so this is the area that's kind of my central bailiwick, which is executive function problems, planning, problem solving, abstract reasoning, learning and memory, academic problems, visual spatial problems, things like that.
Okay. And then, so do you apply the CDC criteria to this as well?
I do, because again, it's talking about impairments in these areas, and these are areas that the neuropsych will assess. But again, more structured criteria that can be applied across multiple cases. So you're not relying as heavily on kind of the clinical judgment of it kind of looks about like it, so let's kind of sneak it in. No, they need to meet that minimum criteria.
All right. And you said, I can't remember the exact terminology that you said about your referral question, but was to assess Nick's neurocognitive functioning. Is that correct?
That's correct.
And how do you do that?
Well, the assessment that I do is based off of a series of tests. And these tests measure the functioning of the brain. I'm not diagnosing or directly measuring brain damage. That's actually a medical term. I'm looking at the function of the brain, and so I'd be looking for brain dysfunction. The tests that have been developed in the field of neuropsychology over many, many years, 100 years by now, probably, usually we learned them originally from somebody who's had some sort of an injury. And then we do a lot of tests, or we interview them and we develop tests to measure what those areas of impact. So people like Phineas Gage, who was a railroad worker, was tamping down dynamite into a hole in order to blast the side of a hill. Unfortunately, the tamping rod set up the dynamite. The tamping rod went up through his, around his orbit, through his brain. From that, he had significant behavioral changes and cognitive changes. And from that, we were learning that the frontal lobes tend to be involved with kind of these higher behavioral and higher cognitive functioning. And then through the research also with other individuals, we've learned about kind of locally what parts of the brain tend to be more involved in certain aspects, like memory, being more involved in kind of temporal lobe damage, things like that. And regardless, in the neuropsych, I'm looking for areas of significant deficit, and that's, I think I mentioned already, where basically 84% of the population does better on this test than the person that I'm testing. So that indicates that they're within the impaired range. And then that is further broken down into levels of severity. So if they're very close to that, if they're in, at the 13th percentile or so, that's mildly impaired. Still significant, but it's mildly impaired. It can also be moderately impaired, much more significantly impacted, or severely impaired, where maybe less than 1% of the population or 99% of the population does better than this person. When it comes to fetal alcohol syndrome, though, or fetal alcohol spectrum disorders, though, because we know from the research over the years that alcohol damages the brain, we have the autopsy studies, we have the animal studies that show it has direct damage, causes direct damage to the brain. Really, when you're diagnosing, when FASD ends up being diagnosed, it does mean that there's brain damage involved.
And just going up to where you mentioned that significant deficit means that more than 84% of the population perform better. Is that one standard deviation?
It is.
Okay. All right. So if you will just continue on and tell us what it is that you are attempting to identify with the testing that you do.
Yeah, I'm looking for strengths and weaknesses. Everybody's got strengths and weaknesses. We're looking for, in this case, Mr. Cruz's particular set. From that, I'm looking to see how his performance on the testing is or isn't consistent with research on fetal alcohol spectrum disorders and the diagnostic guidelines. I look at the timeline of cognitive impacts. So when I do the testing, it's how is he doing, basically right now in 2021 when the testing was done. But I also look at the previous records for prior testing that had been done throughout the individual's life to look to see if there's consistency across time. If a person is having impairments now, but let's say when they were 17 years old, they were doing absolutely fine, no problems, all the way up until that point, and then suddenly they're doing poorly. That's not a pattern that I expect to see for FASD. I'm expecting to see problems earlier in life on cognitive testing and participation in special education services and things like that. I do acknowledge that there are other potential causes for cognitive impairments, and I identify them when I need to. I render the opinion of whether the neuropsych testing is consistent with an FASD guideline, and then it would be referred on to the medical doctor to do their evaluation and to determine if one of the medical diagnoses, partial fetal alcohol syndrome, or ARND would be warranted.
And when you talk about identifying competing causes, is that to say that your testing can identify if it's likely not fetal alcohol spectrum disorder?
It can, especially if the pattern is very much incompatible with what we expect to see. But sometimes there can be other conditions that we know about, like a person has had significant head injuries or a stroke or things like that. Then we can look to see if the pattern is more or less consistent with a head injury versus the fetal alcohol. Okay. And that's what goes into the decision making for the medical doctor when they're making their diagnosis too.
Now, what if a person does have a fetal alcohol spectrum disorder? What is your hypothesis about what you're going to see in their testing?
Yeah, I rarely expect to see them have IQs that are within the intellectually disabled range. The research that we've done over the years has found that yes, IQ is impacted by prenatal alcohol exposure. It's lower in individuals with FAS, and in the research that we were doing at the University of Washington, at that time we were calling it fetal alcohol effects. Now we do partial FAS and ARND. Yes, the IQ scores were lower, but only about 20 or so % of individuals with FASDs had IQs that were within the intellectually disabled range. So I don't expect to see that on a routine basis. I usually will expect to see patchy functioning. They do well in one area, do poorly in another area. Everybody has some variability because, we're better in some areas and worse in other areas, but I tend to see that exaggerated much more significantly and much larger differences between strengths and weaknesses. Academically, I do expect to see impairments. Many of the individuals with FASD go through or receive an IEP or exceptional student status. So I do expect to see academic impairments. Oftentimes math is most significantly impacted. It's not always the case though. I do usually expect to see visual spatial construction deficits. So being able to look at something complex and recreate it is very difficult for individuals with FASD. We've been seeing that in the research since the 80s. I very often will see social and adaptive impairments, again, doing worse than you expect based off of their IQ. And often those adaptive skills are measured to be within the range of intellectual disability. So even though the IQ may be in the normal range, their ability to apply that on a day-to-day basis is often within that intellectually disabled range. So there's this disconnection. Executive function deficits, these higher order things of planning and problem solving, generating ideas, we often will see impairments there. Often we see that even more in tasks that are less structured or settings that are less structured. When I do an executive function test, some of them I tell you exactly how you're supposed to solve the problem. I give you all the rules. And those are pretty highly structured. You just have to do the task. Other executive function tests, I give you the test and say, you got to figure it out. Have fun. So I don't give any instructions. They have to figure all of that on their own. So that's a much lower structure, requires a lot more effort on their part to be able to figure out how to solve the problems. The other thing that we very commonly will see is variability over time. So teachers and parents have commented on this ever since I've been involved in the field. One day, Johnny, we can teach him this thing. He understands it. He's able to get it. It's great. And then 2 days later, it's almost like he's never seen this before. And then maybe a week later, he gets it again. So it's this variability across time we do tend to see in individuals with FASD.
And these, would I be correct to say that these are all indicative of cognitive impairment? Is that right?
Yes, cognitive, behavioral, and adaptive impairments, yes.
Okay. And have these kinds of cognitive and behavioral impairments from prenatal alcohol exposure been able to be demonstrated in animal studies?
Yes. Yes, they have. There's one study in particular that that was done back in the 80s. What you've got is this room with the window in it, food source on the other side of the window. You put a normal chick, normally developing chick, you put it into this room, which by the way does have a door out the back side. You put the chicken into the room, it sees the food, it runs towards the food, it'll bonk its beak on the window. May do that a couple times, but eventually it will decide that's not the best choice. It'll start looking around, it'll find this door, go out, get the food, be very happy. You grab the chick, put it back into the room. May take a couple of trials, but very quickly it learns, go out the door, get to the food. And it learns that skill very quickly. You take the chick away, and maybe a couple weeks later, you put it back into the same room again. It may take a couple of tries again to remember, but very quickly it remembers, oh yes, I need to go out this door, gets to the food. It's a happy camper. You take a chick that's been exposed to alcohol in the egg. It sees the food, runs towards the food, bonks its beak on the window, picks itself up, sees the food, runs towards the food, bonks its beak on the window, picks itself up. It does it over and over again. What we call it in the neuropsych field is perseverations, doing the same thing over and over, even if it's not beneficial for you. It may eventually find the door, get out, get to the food. It becomes a happy camper. You grab it, put it back into the room, it sees the food, runs towards the food, bonks its beak on the window, picks itself up, sees the food, runs towards the food, bonks its beak on the window. It has a very hard time learning how to solve the problem. It may eventually learn it. It takes a lot of extra practice, a lot more than the control chick ever did. A couple weeks later, you put the chick back in. It's almost like it's never seen this before. Sees the food, runs towards the food, bonks its beak on the window. It has to completely relearn again. It has not remembered the strategy.
Thank you. And I just want to make sure that I'm right about a couple of things. The term fetal alcohol effects, or FAE, that is not used anymore. Is that correct?
That's correct.
And what are the current conditions that we refer to now that would have previously been referred to as FAE?
So partial fetal alcohol syndrome, PFAS, or alcohol-related neurodevelopmental disorder, ARND.
Okay. So PFAS and ARND are what we used to call FAE. Is that right?
Yes. Yeah.
And then the other population of people with FASD is people who have fetal alcohol syndrome. Is that correct?
Yes.
So can you help us understand the how the IQ differs between the normal population, people with FAE, and people with FAS?
Yeah, as far as IQ goes, full scale IQ, there is a slight step down. Normal population average score is 100. In the FAE, or now PFAS ARND community or group, the average score, IQ score is 90. And within the FAS group, the average score was 79. So within the borderline range. But again, like I said, still only about 20% that were within the intellectually disabled range. The other thing about IQs is that in the studies that we were doing in the 90s at the University of Washington, we found a very large range of scores. Anywhere from, a score of 20, which is profoundly intellectually disabled, all the way up to scores in the 120 range. So very wide range. So really IQ in and of itself, the full scale IQ, isn't all that helpful when it comes to fetal alcohol spectrum disorders diagnosis. What we do tend to see is more variability across IQ domains. So when you do an IQ test, you look at verbal skills, you look at nonverbal skills. Nowadays, we're looking at kind of working memory or working memory sorts of skills, or processing speed sorts of skills. And we tend to see much bigger discrepancies between those different domains in individuals with FASD.
You mentioned that one of the things that is considered in your assessment is adaptive functioning. Can you please just describe to us what adaptive functioning is?
Yeah, it's basically how a person can apply knowledge that they have on a day-to-day basis independently without extra help, without help from others. So can they meet standards in the community of, taking care of themselves, of their ability to communicate, of their ability to interact with others? And usually when we look at adaptive functioning, it's we're looking at those three areas: the kind of day-to-day skills, communication, and social interaction, social perceptions, things like that.
Okay. And so you said it includes the conceptual domain. Is that the one you just described?
Yeah, conceptual domain includes kind of communication issues, ability to apply knowledge, and things like that.
Okay. Now, you touched on this a minute ago when you were talking about the IQ, but can you give us a sense of, in terms of people that have a fetal alcohol spectrum disorder, their IQ versus their academic performance versus their adaptive functioning, and what you tend to see based on your experience, how those three things relate to one another?
Right. We very commonly will see this descending pattern where IQ is up here, maybe in average, low average range. Academics are lower than you'd expect based off of IQ, kind of a pattern that you would see in learning disabilities. But then adaptive skills are much, much lower. Again, that ability to apply the knowledge, like you get from the IQ, on a day-to-day basis, much, much lower. Like I said before, oftentimes their scores are actually within the intellectually disabled range by comparison to an IQ that may not be anywhere close to that.
And I think you said that people that are diagnosed with fetal alcohol syndrome tend to have the lower IQs. Is that correct?
Yes.
And then people with FAEs, which includes partial fetal alcohol syndrome and alcohol-related neurodevelopmental disorder, they have lower IQs, but not as low as FAS individuals. Is that right? On average,
yes.
But in terms of what you just described, the discrepancy between IQ, academic functioning, and adaptive behavior, is that across the board for people that have fetal alcohol spectrum disorder?
It tends to be worse for those with the FAE, the ARND partial fetal alcohol, because their IQs tend to be a little bit higher, but they're having almost the same level of impairment adaptively as individuals with FAS. So the discrepancy is even more extreme.
Okay. Along that same line, I was wanting you to describe to us the concept of secondary disabilities within the realm of people who have fetal alcohol spectrum disorders.
Yeah, so secondary disabilities are problems that a person faces in their daily life that aren't directly caused by the alcohol and the damage to the brain, but they kind of come as a result of that. So having impairments in cognitive functioning and math calculation puts you into positions where you have more academic difficulties. That academic difficulty is a secondary to the underlying neurological issue of the impact of the alcohol to the brain. We can look at that in a lot of different areas. So the secondary impact of alcohol on the disrupted school experiences. People with FASDs tend to have much higher dropout rates, suspension rates, expulsion rates. They tend to get into trouble with the law considerably, quite frequently. And individuals with FAS, with what used to be FAE or partial FAS, ARND, oftentimes have greater difficulties, greater secondary disabilities than the people with fetal alcohol syndrome. Seems kind of counterintuitive considering their IQ tends to be a little bit higher, but think about somebody with, let's say, Down syndrome. You look at a child with Down syndrome, you see a very specific facial feature. You know, okay, this person has some difficulties. We recognize the face of Down syndrome. So we tend to provide more services for that person, tend to give them a lot more supports. Same thing happens with fetal alcohol syndrome. They are unusual looking kids. They have this very characteristic set of facial features. Oftentimes are very short statured. They get recognized earlier. They get diagnosed earlier oftentimes. And so they get the services that they need that are appropriate to them. So they oftentimes actually have less troubles with all these secondary disabilities because they're getting those supports. The people with the partial FAS or ARND, they don't have a lot of those physical features. They can get missed much more easily. So we assume they should do just fine because they don't look odd. And so they aren't necessarily getting supports. They may be getting diagnosed much later in life. So they're not getting the supports and services that are appropriate to an individual with FASD. So they tend to have greater difficulties in many of these areas.
And do those secondary disabilities involve, I know you said, I think you said problems with the law, but what types of things, based on your expertise, do you see in terms of those secondary disabilities?
Yes, it could be troubles with the law, and it's a whole range from, property crimes all the way up to, in our case, murder cases. As far as troubles with the law, but again, school experiences, being confined, whether it be for criminal cases, mental health confinements, or substance use confinements, things like that. Alcohol use problems, again, very common in individuals with FASD themselves. And so in all of those areas, we see this increased rate of these secondary disabilities.
All right. Can you describe to us the actual neuropsychological testing battery that you have put together and how it was that you came to put it together the way that you have?
Okay. The battery is based off of research that either I've done when I was at the University of Washington doing assessments of adults who had been diagnosed with FASD in the research, and other groups around the country who have done assessments and research on individuals with FASD. And so from that, we're looking at a number of domains that are salient to the impact of prenatal alcohol exposure. Some of these are direct tests that we used, or versions of the same test that we use in the research that I carry over. Others are measuring similar skills to what we found in research, although the research test that we used wasn't clinically based, so we needed to find a clinical test that was measuring basically the same thing. So from that, I assembled this battery of tests that I will typically administer in my cases when I see somebody who is suspected of fetal alcohol spectrum disorder.
And you said you've been involved in this research since when?
Since 1995.
Okay. And now these various acronyms on this page, are they names of a given test?
Yes, and so I'm looking at the different domains. So there's the IQ domain, intellectual functioning, and one of the predominant tests that's used is the Wechsler Adult Intelligence Scale. I will usually use that test. There are other IQ tests that are out there. Achievement testing. When I do the assessments, I usually am using the wide range achievement, but there's also the Wechsler individual achievement tests that can be used. There are a number of other tests that are measuring the same sort of thing. Again, visual spatial construction, there are these certain tests that I typically will use.
Okay. And are these are tests, you haven't created these tests, is that right?
No,
okay.
No.
And the reason why you have this battery is over time you have found what about this battery?
That the tests that were used in these tests are either the same as or are measuring the same function as was used in the research, and they were tests and skills that we know from the research to be impacted by prenatal alcohol exposure.
Okay. And forgive me if you've mentioned this, but is this a battery that you have published?
Yes, we published a set of guidelines for our diagnostic process in 2010, 2011, I think is when it officially came out, that talked about the protocol of how we apply the Institute of Medicine and the CDC criteria, and listed a number of these tests. It's been refined a little bit over the years, and just recently in 2021, a book was published in which I wrote a chapter that updated the neuropsychological side of the assessment process for FASD, and so it has an updated listing of recommended tests that would be used when assessing for FASD.
As part of your assessment, do you review records on the patient or the defendant or whomever it may be.
Yes.
And can you please explain to us why that is?
Like I said before, from the neuropsychological side of things, I'm looking at their current functioning, but I want to be able to document or understand that they were demonstrating cognitive difficulties earlier in life, and not just suddenly right now. So I review those records. Predominantly, those would be school records, prior psychological records, prior neuropsychological records if they've been done, medical records, especially if there were other kind of neurological issues, traumatic brain injuries, strokes, things like that that might have occurred, seizures, sorry. So those are the sorts of records that I look at. We also look at records relating to prenatal exposures to see if there's documentation of that in the record.
Okay. And can you tell us about, for purposes of this case, what records you reviewed that you found to be relevant to your assessment?
Again, predominantly the school records. There were a couple of psychological evaluations done when he was younger that were done that had testing that were pertinent. Some medical records, including adoption records and birth records, that were pertinent for the issues of exposure history.
Okay. And when you say exposure history, we're talking about prenatal alcohol exposure history. Is that right?
Yes.
Okay. And please tell us what you found that was important to you in the adoption records.
Brenda Woodward.
Let me just stop you for a second. Brenda Woodward is who?
Is Mr. Cruz's biological mother.
Thank you.
When she was, this was in adoption records, when she first completed the paperwork for adoption, she was putting Mr. Cruz up for adoption. She acknowledged drinking beer 3 times a week during the first 5 weeks of pregnancy. She also, she denied cocaine use, but talked about smoking cigarettes as well. Later in the pregnancy, in July, she reported past use of drugs and substance use treatment being involved in it, but acknowledging drinking beer during the first 3 months of pregnancy and smoking a pack of cigarettes daily, which was an increase from her report from March of 1998, which is not at all uncommon to see kind of as a person is more willing to discuss, then they tend to report higher levels of substance use.
All right. Now, what about the birth records? What did you find important to you in those?
Yeah, in the birth record itself, there's significant psychosocial history. It says patient admits to alcohol abuse, states a little bit fuzzy, but I think it says currently in treatment center. So she was acknowledging alcohol abuse and that she was involved in treatment.
And from your expertise as a neuropsychologist, is there any significance to using the word abuse in a record like this?
Yeah, I mean, abuse usually indicates a level of magnitude more use of alcohol. It's causing more problems for the person, things like that. They're using greater quantities, greater frequency, and it's, like I said, it's causing them difficulties in some aspects of their social life versus just, yeah, I have had a drink. I have used alcohol.
Okay. And based on what you have reviewed in this case that pertains to Brenda's drinking while pregnant, you've mentioned the adoption records and the birth records. Are you aware of other sources that have confirmed that she was drinking and or using drugs while pregnant?
My understanding that there was testimony earlier by Carolyn Deakins, who was a friend of Ms. Woodward, who testified to alcohol use during pregnancy, and also her daughter, Danielle Woodward, who had testified to alcohol use during pregnancy.
All right. Now, in these cases, is this a level of documentation about drinking while pregnant that you are accustomed to finding?
In some ways, it's actually more than we're accustomed to finding. We don't often find contemporaneous, meaning at the time of the pregnancy. We don't always get contemporaneous records that talk about using alcohol during pregnancy. So this was kind of an additional level to what we normally would expect to see. So this was, well before involvement in this case. It's known that alcohol use was on board during the course of the pregnancy.
All right. I'd like to ask you to begin describing to us the actual neuropsychological assessment that you did of Nick, and we'll just, I'm assuming that you began with the battery that you've already showed us. Is that correct?
Yes, in this case, testing was actually split between myself and another doctor, another neuropsychologist, because of there were questions about possible autism spectrum disorder, things like that. So the testing was split up between us. I was focusing on the fetal alcohol spectrum disorder side, and Dr. Black was focusing on the autism spectrum side. But all the data can be brought together for either, and in the end, it was brought together for the fetal alcohol spectrum disorder side of things.
And did you incorporate any of the tests that Dr. Black did into your assessment?
I did.
Did you incorporate all of the testing that he did?
No.
Why is that?
Some of the testing that Dr. Black had done were tests that are primarily focusing on autism spectrum disorders, and that isn't part of what we're looking at for the FASD now. He'd looked at it for the autism spectrum. It wasn't seeming as fruitful, so the focus shifted. He also gave a couple of self-report measures of kind of that Mr. Cruz filled out, basically, of his behavior, which is something that his understanding of his cognitive functioning, which I tend not to do, especially in individuals with fetal alcohol spectrum disorders. We often see that they are pretty suggestible. And so if you give them a test that says, do you do this, do you do that, they may have a tendency to say, yeah, I do, hey, because they're being because it's suggestibility rather than they actually are having these sorts of problems. So I tend not to give self-report measures, so I didn't include those in my battery when I blended the two batteries together.
And the test that you included in your battery that Dr. Black actually administered, did you do anything to verify the accuracy of the scoring that he did?
Yes, both he and I double-checked the scoring. We did find a couple of small errors that were corrected. Didn't change the interpretation in any way, but they were corrected quite a long time ago.
So why not just re-give Nick the test that Dr. Black did instead of using Dr. Black's scores?
Yeah, well, many of the tests that we give in neuropsychology can be impacted by practice. So if you give the same test twice, it's not at all unexpected to see them get better the second time you give the same test. And in fact, it's kind of expressly told not to for a number of tests that you need to give it a good period of time before you re-administer a test. So on those tests that it would be inappropriate to re-administer because it might decrease the validity of the test, I didn't re-administer them.
And is that what you just described? Is that something that is sort of a part of neuropsychological testing? Is the concept that you can't give somebody the same test in close proximity?
Yes.
Okay. All right. Now, I'd like to ask you to describe the various testing that you did of Nick, and if you would first start with what I think you call effort testing and tell the jury what that is.
Mm-hmm. Yeah, so as part of the evaluation, I want to make sure that Mr. Cruz is working hard. He's trying his best. he's not, lollygagging. He's not, ignoring me. He's not actively trying to show himself to be doing poorly. So in order to do that, we administered a number of tests that measure the validity of their testing throughout the course of the evaluation, not all clumped together, but spread out. Some of these tests are embedded in other tests, and others are kind of standalone tests. And so taken together, they're called performance validity tests. There's actually two types of effort testing or validity testing that's out there. This type, the performance validity, is looking at cognitive and neuropsychological validity on tests that are similar to things that I'm giving, that I'm measuring, let's say memory. We're giving memory tests that look hard. They're not actually very hard. So we're looking to see if they're what their performance is and whether they're putting out strong effort. Another type of validity test is what's called symptom validity. So this is more relating to mental health side of things. Their depression, their anxiety, their unusual experiences, psychotic symptoms, things like that. Those symptom validities are questionnaires usually that relate to, have you had troubles with this in your life? Have you tried troubles with that in your life? And so it's asking these drawing these more questions of behavior. I'm not focusing on that with the neuropsychological evaluation. I want to see how they do on cognitive sorts of tests. So this is a listing of the tests that were administered throughout the course of the evaluations, both by me and Dr. Black. Again, spread out. We don't tell them, hey, this is the effort test now. You gotta work hard on this. No, this is another test. And in all of those tests, Mr. Cruz was putting out very good effort. He was making very few errors, and he was working quite quickly on the tasks. So these were all showing that he was working hard throughout the course of the days of the assessment.
Is effort testing similar to what people call testing for malingering?
Yes. One end of the effort spectrum is malingering, the very far end, where a person is attempting to fake their performance for a secondary gain, whether it be for money, if it's a civil case, or for in a criminal case to try and evade the consequences. That's just one extreme end. There's all kinds of other ways that a person could be putting out poor efforts. They could be very tired that day. They could be sick. They could not like me, think I'm a jerk, and not want to work for me. So there's all kinds of reasons why a person could be doing poorly on these effort tests. One of them is that they might be malingering.
Okay. And if malingering is at one end of the spectrum, is it correct that Nick scored on the other end of the spectrum?
Yes.
Now, if you would describe to us what you discovered regarding Nick's IQ based on your or Dr. Black's testing.
Right. So these are the domain level scores on the Wechsler Adult Intelligence Scale that were administered to Mr. Cruz, and then the full scale IQ. The full scale IQ was an 83. That is in the low average range. It's actually slightly lower than what we've seen in our research on individuals with FAE, so partial FAS, ARND. The other thing that we note on the intellectual testing is across those domains, there is significant variability between his high score, 93, which is very much in the average range, and a low score on working memory, which is in the borderline range. So much lower, many points difference between these two. So that variability across domains, like I said, I do tend to expect to see. I am seeing on the testing that was done with Mr. Cruz.
And so is
Similar
similar
variability across the subtests, where he's got scores that are in the mildly impaired range up to very much in the average range.
And is this performance on IQ testing what you would anticipate seeing in a person who has a fetal alcohol spectrum disorder?
Yes, like I said, his full scale IQ is a little bit lower than somebody with ARND, or the research on individuals with ARND or partial FAS on average. but yes, it's very much in keeping with what I would expect to see.
Okay. Now, if you could describe to us how he scored in the various neuropsychological domains that you tested him for.
Right. So you can do that by just showing a person a bunch of scores, bunch of numbers. But for me, it seems to help a little bit to look at a picture, basically, of a person's scores. And that gives you a visual representation of where they have strengths, where they have weaknesses. So I create this graph in order to do that. Like I'd said before, there are a bunch of different types of scores that we see in neuropsychological testing. So sometimes an IQ score with a mean of 100, T scores with a mean of 50, scale scores with a mean of 10. That gets really confusing to tell which one's which, even for us. We need to know what tests creates what scores. So in order to kind of get around that, comparing apples to oranges, we convert all of the scores to a single standard score, a Z-score. That was that one that I told you had a mean of 0 and a standard deviation of 1. All the scores get converted to that. It doesn't change the range of the scores. It doesn't change any of that. If it's 1 standard deviation below the mean, it's 84% of the population or 86% of the population does better. It stays exactly the same, just everything's on a same scale so that we can compare across. One of the other downsides of neuropsychological and psychological testing is sometimes a high score is good, sometimes a high score is bad. You have to know the test in order to figure that out. So I convert everything so that a low score means bad performance. All that is flipping the sign. Doesn't change the valence, just flips the sign, or doesn't change the value, it just flips the sign so that the low score is poor.
Okay, Mr. Seeker, I think we're gonna take a break for lunch now, okay? Ladies and gentlemen, it's 1 o'clock. Please be back at 2:30, promptly at 2:30, so we can start back up. Please do not discuss the case. Please leave your notepads behind. We'll see you at 2:30. Thank you. Okay, the jurors have been excused. We're in recess until 2:30. Unless you all have something else that needs to be brought up, then please be back at 2:15 or however early you think we need to start. Please, because I don't want to keep the jurors waiting. Thank you.
Judge, I don't know, it seems like especially cold in here today. I don't know if you can do anything.
Okay, I'll see if I can
Thank you.
adjust. Okay, the jurors are all present. Everyone else may be seated. Whenever you're ready. Let me just make sure. Dr. Connor, can you hear me, sir?
Yes, I can.
Okay, we're going to resume. You're still under oath, and Mr. Secor is at the podium, and he's going to continue his questioning. Thank you.
Thank you, ma'am. Dr. Connor, if you would put up the slide that you were on when we left, entitled Neuropsychological Testing of Nikolas Cruz.
Can you see that?
Yeah, we see the entire, there you go, that's the full screen.
Perfect.
I just want to make sure that you were able to finish the thought that you had when we broke for lunch, but I believe you were saying that you converted Nick's scores into what you were calling Z scores, is that correct?
That's correct. A mean of 0.
Okay, and just
And then
remind us, I'm sorry, go ahead.
And then I flipped all the scores where a high score is bad so that a low score would be bad. So they just flipped the sign. I think that was where we left off.
Okay, and let me just ask you a quick number of questions before you describe to us the significance of the graph. But along the bottom, the text across the bottom of the chart is what?
Those are the test items, the names of the test items.
Okay, and then they are separated by the vertical black lines into what?
They're separated into domains, and the domain name is listed across the top.
And those domain names, are those the domains identified by the Institute of Medicine?
They were some of the domains identified by the Institute of Medicine, yes. These are domains of neuropsychological functioning that we use very frequently.
Okay, and then I'm correct that the red line is the indication of a deficit as indicated on the chart, right?
Yes, per the CDC guidelines, -2 standard deviations for IQ testing, and then -1 standard deviation for all other neuropsych testing.
Okay, and both of those standard deviations are set by the CDC, is that correct?
Yeah, those ranges were set by the CDC. It's also a fairly common practice for neuropsychology in general.
Okay, and then of course the green line, that's at 0 standard deviations, which that's you're just average person, is that correct?
Yeah, that would be the average score for each one of these, what you anticipate.
And then the blue line that's indicated on the chart as current testing, is that Nick?
Really, the dots are Mr. Cruz's scores on each of the tests. The lines are more there just to kind of help you see the pattern. It's not indicating any relationship between the scores, but it's just to help draw the eye to the dots.
Okay, and so if you would describe to us what each domain means, and then how Nick tested in each of those domains.
Okay. So the first domain having to do with IQ, intellectual functioning, standard testing of that. He had a full scale IQ. We've seen the scores of 83, and so that's what this dot here is. The green dotted line is actually his score on the IQ, full scale IQ score, so that we can kind of compare his performance on other tests against that. Like I talked about, there were very significant splits across the domains of intellectual functioning, as you can see in this image here. Second domain has to do with academics, reading, word pronunciation basically, reading comprehension, spelling, and math calculation. All of them are below the 1 standard deviation cut point, predominantly in the mildly impaired range, with spelling that's within the mildly to moderately impaired range. Memory testing is looking at a person's ability to learn and remember information. It's both, I assess both verbal and visual spatial. The first half of this, approximately, well, till about here, has to do with verbal learning and memory. This first one is a list learning task. I read a bunch of list of words to the person. He has to repeat them back as much as possible. This first score is how much he learns, and we repeat the list a number of times to see how they learn with practice. The first dot here is Mr. Cruz's score on the learning portion of the test, the list learning test, and that was within the low average range. But he was able to retain the information, those lists, very well over time. They were in high average range for both a short delay and a long delay. Next set of scores had to do with more contextual learning, so learning of a story. This one was a relatively short set of stories, and on that he was in the low average range, both for immediate recall of them and delayed recall. The third verbal test was again a contextual learning test, but it was a much more in-depth test. There were more components to the story. And on this, he was demonstrating significant impairments within the mildly to moderately or moderately impaired range for learning, and then mildly to moderately impaired range for delay recall. Then we move into the visual side of memory on a relatively, where he's having to copy and then recall relatively simple geometric designs. He was within the low average range for immediate recall, average range for delayed recall. But again, when you have him try and copy and remember a more complex design, he was demonstrating significantly more difficulties in the severely impaired range, moderately to severely impaired range. Next domain has to do with visual spatial construction, so being able to copy this complicated figure. And in this, he was functioning within the severely impaired range. He had considerable difficulties being able to organize his thoughts in figuring out how to approach copying a very complicated figure. Made a number of errors in the accuracy of his reconstruction. This is something that we see extremely commonly, like I had indicated as earlier on, my expectations. We see this very commonly with individuals with FASD. Next group has to do with attention. There were two different attention tests that were given. Both of them were kind of more long-term vigilance tests where he has to pay attention for a long period of time. And on both of them, he was actually doing quite well. In the normal range to above average range. Wasn't making many mistakes. He was able to stay focused. So he was doing quite well. Interestingly, when he was a child, he was diagnosed with ADHD, but at the time of the testing, he wasn't demonstrating significant problems with that. Next domain has to do with processing speed. How you take in information, figure out understand what it is that you need to do, and then come up with a response to that. And these were relatively simple tasks that he was having to do, so it was looking at very basic processing speed. On this, he was overall doing reasonably well. He had one score that was in the impaired range, but overall he was doing reasonably well. Similarly, on the IQ testing, his processing speed score was within the average to low average range, so not too bad. Motor tasks, motor coordination. I do a couple of different tests relating to that. One of them is kind of fine motor eye-hand coordination where you're trying to put small objects into holes. And then the other one is more of a motor speed task, having to tap a key as quickly as possible. On the eye-hand coordination, he did fairly well, average to slightly below average range. But on the motor speed task, he was demonstrating significant impairments, both using his dominant left hand predominantly and his non-dominant right hand. The next large group of scores here have to do with executive functions. I kind of bounced around talking about those a little bit. Their planning, their problem solving, idea generation, things like that. And on this, he was demonstrating, and so it's not measuring a single sort of skill. It's measuring a bunch of different sorts of skills. And so on this, he was demonstrating a fair bit of variability depending on the type of executive function that was being measured. This first group had to do with idea generation, either verbally coming up with words for names, for letters, or for different types of categories of items, or generating unique ideas visually. He demonstrated mild or mild to moderate impairments in his ability to generate ideas. He also demonstrated perseverations, where he would get stuck on an idea and repeat it over and over again. Next group of scores had to do with being able to inhibit behaviors, inhibit a well-learned response. Again, he was demonstrating mild, moderate impairments on that. When you took in, oops, sorry, my bad. When you took into account how quickly he did the tasks, it was still mildly impaired in his ability to inhibit behaviors, inhibit responses. This trails B is a task of having to quickly shift the focus of your attention. And he demonstrated significant troubles being able to adjust his focus. This next group of tests had to do with a problem-solving task that was relatively well described to him. The instructions were given pretty concretely, and all he had to do was just solve the problem, and overall did fairly well, but he demonstrated a lot of rule violations where he would not follow the rules that were given to him. Again, that was in the mildly to moderately impaired range. On a task of working memory, this is where a person has to do multiple things at the same time, keep track of multiple things. He was demonstrating considerable impairments, especially when he didn't have a lot of time to kind of get accustomed to doing multiple things. When he had time to get accustomed to it, so this is when he's doing two things at once for a short period of time. This is for an intermediate period of time, and this is for a long period of time. When you had him do it for the long period of time, he was doing a little bit better, but it was still mildly to moderately impaired. He still had difficulties, considerable difficulties, being able to manage multiple things at the same time. A test of problem solving where he has to quickly shift between different types of problem solving. Some of them are mathematical, some of them are language, some of them are more visual spatial. And he had difficulties with that performing in the mildly impaired range. On another task that was a little bit more abstract in its problem solving, and where we don't give a lot of instruction on how to perform the task, he was still doing reasonably well, but it took him many trials to be able to figure out how to solve the problem. So initial problem solving for him was very difficult. Once he got the idea, he was able to do a little bit better. Kind of fits with the working memory, where if he became accustomed to it, he was able to do a little bit better. Then we've got another abstract reasoning task where it's dealing with language-based abstract reasoning. And he was kind of right in the borderline to mildly impaired on his ability to understand abstract concepts. The last group of tests within the executive function realm has to do with suggestibility. Like I'd said, people with FASD often have a lot of difficulties. They tend to be highly suggestible. So we have them learn a story, and then we ask them questions about the story. And then we tell them that they made mistakes. They have to go through the questions again. So we see how many times they endorse misleading or questions that are not part of the story the first time through, and how many times they do the second time through, so how many times they shift their answers. And with Mr. Cruz, kind of low average range for initially agreeing to items that were not on the story. But when we went through the story the questions the second time, he was demonstrating much more impairments. So his overall suggestibility was within the mildly impaired range. This last group here have to do with 3 different domains. They all relate to adaptive skills, adaptive functioning, day-to-day life. One of them has to do with language, both expressive and receptive. Another has to do with social interpretation of social cues. And then the third one has to do with day-to-day skills, counting money, telling time, things like that. And those are direct measures that were administered to Mr. Cruz. This was a interview that was, that was completed with Mr. Cruz's adoptive mother when Mr. Cruz was 3.5 years old, looking at those same areas of adaptive functioning. And we see that he's demonstrating on direct testing, either mild or mild to moderate impairments in receptive and expressive communication, also noted by the mother on the interview when he was young. Social interpretation was a little bit less impacted on current testing, although he did have a score of where he had significant difficulties making inferences of emotional content. But other areas or other aspects of identifying, facial expression or other issues of tone of voice was not in the impaired range. Although at the time his mother indicated that it was his stronger suit, but still an area of weakness. And then in daily living skills on current testing, he was demonstrating significant impairments.
All right, thank you. Just a couple of questions before we move on. The effort testing that you described to us earlier, is it the effort testing exists throughout this graph, but it is not specifically identified?
Yeah, they're not identified in this graph. They're not scores that you would interpret for level of functioning or dysfunction. They're check digits to see if the person is working hard.
Okay.
The testing was administered throughout the course of all these tests that were given.
And I think you partially answered this, but just so that I'm clear, why are there numerous tests in some domains, fewer in others, and then in at least one, there's only one test in the visual spatial domain? Right.
These are the sorts of tests that we found in research to be very consistent. Or very sensitive to the impact of prenatal alcohol exposure. And one of the primary ones, let's just talk about the visual spatial, because there's only one score. In visual spatial, one of the primary ones that's been found in almost all the research has been this particular test, the Ray complex figure copy, that it is particularly sensitive. Having said that, he had difficulties on nonverbal visual spatial construction on the IQ test as well. I just don't include that into this visual spatial domain.
Okay. And you described for the motor domain that requires Nick to be actually taking an item and then placing it into some sort of keyhole or something. But regarding the other kinds of testing, are these verbal tests? Is he writing something down, or are you writing down what he says? How does it work?
It's a combination. Some of them are simply question and answer. I'm asking questions, he's answering, I write it down. Others, he's doing a computerized test. Others, he's actually manipulating items. So it's a lot of different sorts of things. Some of them are all verbal, some of them are more visual. And
what do you do to ensure that you're getting down the most accurate information when he's giving you answers?
Yeah, when I'm recording his responses, if he's giving me verbal responses, I will type because I type much quicker than I can write. My handwriting is not very legible, and also I do have some troubles with my hands that I get some pretty decent pain when I'm writing for any length of time, and I can type a whole lot quicker. So I'm able to type and keep up with what he's saying while when he's answering questions.
Okay. Now, did you compare the neuropsychological testing results? Well, actually, let me ask you this first. I'm sorry. What you see once you graph Nick's scores, is this indicative of the pattern that you would expect to see of somebody with a fetal alcohol spectrum disorder?
Very much so. Like I'd said before, we're looking for at least deficits in at least 3 domains that are at least 1 standard deviation below the mean, or discrepancies. We have discrepancies on IQ. That's 1. We have academic impairments. We have memory impairments, learning and memory impairments. We have visual spatial impairments, motor impairments, executive functioning impairments, receptive and expressive communication, both on direct and on informant report, and mother's report from childhood, and socialization impairments reported by mother, less obvious with on direct testing, and daily living impairments. So 9 out of the 11 domains that were assessed here had impairments.
And you said that you would need 3 for somebody to be consistent with having an FASD. Is that correct?
Yes.
Okay. And if you are, according to the neuropsychological standards or standard deviations, if you're below 1, I think you said that's a mild impairment. Is that correct?
Yes. Between 1 and 2 standard deviations is essentially mildly impaired. There's gradations that you can do from there. From 2 to 3 is moderately impaired, and from -3 and below, it's severely impaired.
And does that descriptor, whether it's mild, moderate, or severe, does that have any bearing on whether or not the domain is met for purposes of your assessment?
No.
All right. Did you compare your neuropsychological testing or neuropsychological testing scores of Nick to any other neuropsychological testing done of Nick?
Yeah, the state had asked for an expert to go in and do some more testing with Mr. Cruz after mine had been completed, and he administered a number of tests, some of which overlapped with the ones that I'd given or we'd given, but others were slightly different. The state's expert did do performance validity testing. So looking at how much effort Mr. Cruz was putting out, he performed well on that test. So there was no indication that he was malingering or putting out poor effort. So that's with respect to the performance validity. He also gave some intellectual testing, a different test than the one that we use. We use the WACE. He used what's called the Reynolds Intellectual Assessment Scales. He actually ended up with much lower scores than were found on the IQ testing that was done by, actually Dr. Black had done this testing, but found very similar overall intellectual functioning, 83 versus a 78. That's about 5 points difference, and noted splits across the domains of IQ consistent with the testing that was done by myself or Dr. Black. Oops, sorry. Similarly, processing speed, he did administer the processing speed domain from the WACE, and scores were very consistent across, 92 when he was seen by Dr. Black, and 89 when the state's expert saw him, very consistent. Copying of that complex visual spatial figure, both times severely impaired range.
All
right. He did some more testing. The memory component of that complex figure did slightly better on the testing by the state's expert, but still well within the impaired range. For immediate recall, so very short recall after a couple of minutes. Delayed recall, again, severely impaired on both assessments. When he did the testing with us for looking at just recognition, was this on that figure? Was that on that figure? He did slightly better, still impaired, slightly better, and had more difficulties when it was done by the state's expert. 2 different types of other aspects of visual learning and memory. But overall, did slightly better on the testing that was done by Dr. Black and myself, slightly more difficulties and mild impairments on shape learning from the state's expert assessment. And then the state's expert administered the Mazes test, which is not one that we've used. We haven't done any research on that in FASD. So honestly, I don't know how that would usually play out for people with FASD, but in this case, he was in the average range. When we did a testing that looked at sort of an aspect of tracking, he was having greater difficulties on testing that was done. And these were tests that are part of the research that we've done over the years on FASD. He was demonstrating more difficulty. So overall, there was very good agreement. A few areas that were slightly different. And the state's expert and our current assessment both were indicating that that Mr. Cruz was putting out very good effort.
And just so that we're clear, in the upper right-hand corner of this chart, it's kind of being blocked by the image of you, but I think the title of that column is consistent, correct?
Yes, yes.
And then the first word is partial, and the second word is yes, indicating the degree to which it was consistent?
Yes.
Okay. Now, just to make sure that I am correct about this, with T-scores, what is normal?
A normal score, an average score on T-score is a 50.
And the standard deviation is what?
10. So basically 40 would be the cut point. And
so why are there some scores that are just identified regarding being less than 20?
This test, once it gets below 20, it doesn't give you the exact score anymore, the exact T-score. It's just, it is now in the severely impaired range, and anything below it is still severely impaired.
So whether it's 19 or 2, it's considered severely impaired?
Yes.
Okay. Now, next thing I wanted to ask you about is Nick has had IQ testing at various points in his life, and I was wondering if you could describe to us how you see the comparison between those tests that he has received at different points.
Okay. So yeah, he has. So he had a different IQ test, the Stanford Binet, when he was 5 years old, and when he was administered that, his full scale IQ was 77. That's in the borderline range. He also demonstrated a little bit of variability across domains, was poorer on the verbal, a little bit better on the nonverbal, but verbal was in the borderline range, nonverbal was in the low average range. When he was 10, he was administered an earlier version of the Reynolds intellectual assessment scales. And his scores were better. Had a full scale IQ of 93, and then again, slightly more challenging with the verbal versus the nonverbal. One of the things that research has shown is that in general, the Reynolds, the RIAS tends to score a little bit higher than other IQ tests. So it's possible it could be part of a measurement between the RIAS versus a Wechsler. This was the testing that was done by Dr. Black as part of the current evaluation. We've talked about that overall score. In the low average range, but relatively consistent with the score back when he was 5 years old. And then this was the testing that was done by the state's expert, again, back into the borderline range. So overall, the scores have been borderline to low average, with the exception of when he was 10 years old, and it's possible that is related to the test itself tending to score a little higher.
And the empty boxes there in the working memory and processing speed columns, are those things not tested by those various tests?
They weren't reported in the records, and in some of them they aren't part of the test. But they just weren't reported in the records.
And in IQ testing, I think you said the standard deviation is how many points?
Full scale IQ is a mean of 100. Standard deviation is 15.
Okay.
So here's 1.5, just more than 1.5 below. This is 1.5 below.
All right. Now, next thing, also regarding testing that Nick has had throughout the course of his life, did you look at his academics across his lifespan?
Yes.
But before you go on, let me just make sure that I can't remember where I made this clear or not, but why is it significant for you when you're doing neuropsychological testing to look at a person's performance across their lifespan?
Yeah, so in order for a person's current functioning to be considered consistent with FASD, we need to know that there were troubles during earlier portions of life. If a person was doing fine until they're 16, 17, 18 years old, and then suddenly they have a decline in functioning, it's a pattern that we don't expect to see for FASD. It's a pattern I expect to see for a traumatic brain injury or a stroke. So we're looking to see if there were indications of impairments earlier in life, and so that could be participation in special education services, but especially I'm looking for testing, standardized tests that were administered earlier in life.
Okay. And did you look at that standardized testing of Nick's across across the records that you reviewed across his lifespan?
I did.
And can you tell us about those, please?
Yeah, so from the academic perspective, the red marked sections all are for performances that were below grade level. So these are showing grade equivalents, basically. So when Mr. Cruz was in the 3rd grade at age 10, his reading pronunciation was at a 2nd grade level, below grade level. Similarly for comprehension, spelling was between a 1st and a 2nd grade level. When he was in 4th grade, again, below grade average. And that was pretty much consistent all the way across. There were a few areas where he was doing better at certain times. On more straight calculation type problems on math, he did relatively well in the 5th and 6th grade. But when you do story problems, more complex mathematics, and having to do more abstraction, considerably below expectations based on grade level. And this persisted all the way through until the testing that was done recently as part of this case.
And is that, are the struggles that are represented on this graph consistent with the impairments that were found by your testing?
Very much so.
Then that was regarding academic achievement, but what about communication as indicated by records from throughout his life?
Yes, same sort of a pattern. Now we switch back to percentiles. So what we're looking for are percentiles that are 16 or below. And those are all denoted in the red. Again, there are a couple of times when he's doing relatively well. Again, 6th, 8th grade sort of things. But for the most part, he's doing quite poorly, both for receptive skills and especially for expressive skills. Some of these are within the severely impaired range for both of those. And again, that includes on current testing. So again, it's consistent across his age from pre-kindergarten, when he was 3 years old, was demonstrating significant both receptive and expressive all the way up till age of 22.
Okay. And the few places there where he appears to have scored pretty well, how do you interpret that, or how do you explain that in relation to the other things that are indicative of impairments?
Yeah, we talked about really earlier that there is some issue that people with FASD can be pretty variable. One time they get it, the next time they're not quite following it, or they have greater difficulty. So it's possible that it's down to some of this variability of performance over over the course of time. But he had this Peabody picture vocabulary test in 1st and 2nd grade, was doing okay, but by 3rd grade he was demonstrating significant impairments.
Okay. Now, what about testing from his life in regards to visual motor skills?
Yeah, there was an assessment that was done when he was 5 years old that was looking at a test where he had to copy geometric figures, basically, and his performance was at the 3rd percentile, so that's in the mildly to moderately impaired range. So that was when he was 5 years old, and then the testing that was done as part of this current evaluation, both by Dr. Black, myself, and by the state's expert, was below the 1st percentile.
And when something is indicated as being in the 3rd percentile, or we're talking about the bottom third, the
bottom
Yes.
of the, okay.
Yeah, meaning 97% of the people do better than him and only 3% do worse.
Okay. And what about executive functioning as indicated by testing throughout his life?
Yeah, again, there was some early executive function testing that was done when he was 5 years old, where he was functioning at the mildly to moderately impaired range, 2 standard deviations below the mean. Also at age 5, there was one aspect of that Stanford-Binet IQ test had to do with fluid reasoning and working memory. Both of those were in the impaired range. On the current testing, when you average all of those 32 tests that you saw, or scores that you saw on that graph, his score comes out to 0.9 below the average, below the mean, so slightly above that cut point. But the problem, like I'd said, is that that executive functioning is a lot of different sorts of skills. So averaging a lot of different sorts of skills isn't necessarily the most appropriate way to represent them. But just to give a brief overview.
And finally, and once again, Jake will tell you, George shot no one. Most importantly, there is no reliable evidence that George planned these murders. There's no independent, reliable evidence that George prepared for these murders. And there's certainly no reliable evidence that George shot anyone. That second thing I wanted to talk to you about is Jake and Angela, who are con artists and liars. We've already touched on it some, but Angela's the con artist through and through. You know, you're going to hear evidence that she burned her home on more than one occasion, committed arson, and then collected from her insurance company the proceeds on that. She started doing that when George was just 9 years old. Billy did the same with some vehicles. Billy is a professional thief. Jake took those traits from his mother and his father, all of those bad traits, and put it into one. They are a pair, and that's who the state has as their key witness. Con artists and liars. Jake and Angela fooled many people throughout this investigation, beginning with Mr. Carson on the phone. But you know what they did even after the murders? There's a child, if you remember, Hannah Roden had a newborn baby, and that newborn baby was named Kylie. It was Jake and Hannah who went together, and they brought Sophie over to the Gilly family, a family who they were responsible for taking their loved one, and acted as if nothing happened. That's the type of people that the state has selected as their key witnesses. Afterward, Jake went home and, at the direction of Angela, created a GoFundMe account to collect money, defraud people, to send him money so he could obtain custody of a child. The con didn't stop then. It's continued. It's who they are. The evidence will be that Jake and Angela have conned the state of Ohio here as well. They've conned the state of Ohio into the most heinous crime, into a 30-year sentence. In a sentence most deserving of death, he escapes with life. The plea deal is what I'm speaking of. Jake and Angela have conned the state of Ohio with the greatest goal in mind, perhaps the most remarkable plea deal possible. As the prosecution said, the loss of 8 innocent lives. The most deserving of the death penalty, and Jake gets to walk. Angela gets 30 years. They negotiated this plea agreement to save their life. Prior to making this plea agreement, they had reviewed all of the evidence in this case with their attorneys. And so it begs the question, why in the world? Why in the world would you grant such a gift to Jake and Angela, to give them this in exchange, purchase that testimony? Well, it's simple. And it goes back to that last question that Hageman had. You're either a witness or you're a suspect. Because you see, there's no physical evidence George was at any of those murder scenes. There's no DNA, there's no prints. And BCI knew he had no motive. They knew that he was not involved in drugs. And you know, they knew they had only spoke with him one time, and that was for a reason. They have nothing on George. And because of that, that's a testament to the strength of their case for them to grant the deal that they've granted, and they were conned into the sentence that Angela and Jake have agreed. In order to avoid the death penalty, they must implicate George. Now, Angela gave a statement too, but what's really concerning about her story is she'll say that when everybody left to go commit murders, she went to sleep, she doesn't know what happened, and she woke up the next day and it was never discussed. How convenient. She has nothing to offer that would contradict Jake's statement, because according to her, she never talked about it afterward. They never talked about it, and she was sleeping while this all happened. So, Jake's confession. We know that there was evidence gained, and you heard about what was pulled out of that big pond, and you went there and you saw that pond, and there were some buckets that were pulled out of that pond. But, you know, Jake's statement really only implicates himself. There's nothing about Jake's statement that implicates George. Sure, he led him to weapons, but there is no independent, reliable evidence that George was involved in these murders. In fact, we believe the evidence will show that George could not have committed these murders. And it goes further. We believe the evidence will show that Jake, in fact, killed all 8. But he had to implicate his father in actually killing somebody. But the evidence will show that Jake killed all 8. The fourth thing I want to talk to you about is motive. George had his own life. He had his own son. He had everything going for him, and he had nothing against the Rodens or the Gillies. He had no motive to kill any of these people. Everybody but George had a motive. Angela's motive was this unfounded imaginary threat of sexual abuse. She convinced Jake that it was a realistic threat. Jake was already in a jealous rage that Hannah had moved on with her life. And Angela had brought this concern to Billy. Angela's concern, Angela's suggestion was, we should turn him into the police. We should turn him into police because that'll take care of Christopher Roden Sr. because of his drugs. That's what we should do. Well, remember what I said about Billy and his motive? That idea hit too close to home. No, we can't do that. That's what Billy said. The evidence will be that Billy, according to Angela, said, we must kill them. The idea was taken to Jake, and you know, Jake's idea was, again, his jealousy surfacing, said, we should do it, we should kill Hannah, but let's frame Hannah's boyfriend. Let's make it look like Corey Holdren did it. And once again, Billy said, no, that's not what we're doing. Once again, Billy's the one who created the plan. Jake went along with it. Angela went along with it. George had nothing to do with that plan. George had no motive, especially to kill who he considered his closest friends, Frankie Roden. You'll hear that Frankie Roden was one of George's closest friends. And Hannah Roden, you'll hear from many people, Hannah Roden was like a little sister to George. He had no reason to kill her. The last thing I want to tell you about is George's
IQ as compared to his academic ability as compared to his adaptive functioning?
Mm-hmm. Oops, sorry. So yeah, this is Mr. Cruz scores on the current testing. Here's his full scale IQ, which was 83. You've got the dotted line this is what you expect. He's doing more poorly than you expect based off of his academics, which is what we would anticipate seeing with somebody who's has an IEP or so he's doing more poorly there. But when you move into kind of what he knows versus what he can do and how he can apply it independently, he was doing significantly worse. When you look at it in relation to other individuals with ARND or PFA or partial FAS, it's very much the same pattern. This is the type of pattern that I expect to see, where there's this disconnection and downward slope from higher structure, higher knowledge to lower structure and needing to do things more independently.
And in regards to that downward slope, did you see that also in his language testing, memory language testing, as well as visual spatial memory testing?
I did. So on the left side, this is language learning and memory. So when the language test was concrete, highly structured, a list of words, he did well. As the test became more complex, more challenging, having him remember some short stories, not as well, low average. But when I had him trying to remember longer stories and more complicated information in those stories, he had significantly greater problems. So this downward trend from less complex to greater complexity. Same sort of thing with the visual spatial memory. When he had to copy and remember relatively simple figures, geometric figures, did okay. When he had to remember much more complicated figures that weren't necessarily geometrical, considerably greater difficulties, again, as it became more complex.
And is this what you would expect to see in a person with fetal alcohol spectrum disorder?
Yes.
And then how about that downward slope regarding adaptive functioning?
Yeah, so there's a lot of overlap between executive functions and adaptive skills. So being able to generate ideas more independently, being able to understand concepts and things like that. But when you're in kind of the more direct measures, more structured and setting of a test of his skills, he does slightly better than if you're just looking at his ability to do things, if somebody is reporting on his ability to do things on a day-to-day basis. Similarly, we're seeing kind of as his ability to apply some of those things as far as language goes and adaptive skills and kind of daily living adaptive skills, we're seeing this downward trend between the higher structure of direct testing and the lack of structure when it's kind of in the real world, trying to apply those.
Okay. Now, another thing that is tested, if you could just discuss with us briefly, is suggestibility and why that's tested.
Yeah, like I said, we do measure suggestibility. Individuals with FASD do tend to be suggestible. And so we want to assess that as much as possible. And so we do that in kind of, it's kind of like they call it interrogative. It's kind of like an interrogation style where you ask a bunch of questions, say a person does something wrong, it was incorrect, and then they have to ask the questions again and see if they change their answers. And people with FASD are pretty highly prone to that. So we do assess it.
And what did, hang on just a second. How did he score on suggestibility?
Okay. So the first two parts of it, so this is Mr. Cruz's raw score. So the absolute score that he got on each of these items. This first group here is from the test manual. comparing against other individuals, other adults. This is also from the test manual, comparing against individuals that had been diagnosed with intellectual disabilities. This was a small group of individuals with FASD who had been involved in forensic criminal cases, published study. And then this was a published study of individuals with FASD who were just in the clinically. They weren't involved in any litigation or criminal cases. And what we see is that compared to the normal individuals, and we saw that on the graph, compared to kind of the normative group, Mr. Cruz is doing significantly worse with respect to immediate recall, immediately remembering a story, and delayed recall of that story, but fairly consistent with his performances for individuals with intellectual disabilities, the forensic population of FASD, and the clinical population of FASD. Relatively consistent there. When it comes to endorsing the questions that weren't in the story, the first time through, again, not significantly worse than it was trending towards poorer performance. Higher scores bad here. Tending towards poorer performance against compared to the adult general population, but relatively consistent with the other groups. When it comes to going through that same set of questions a second time, and does he endorse more, which he did, that was significantly worse than the adult general population, but relatively consistent with intellectual disabilities or FASD. When it came to the actual shift, how many times did he really change his answers? Again, worse than general population. He actually did a little bit better than the FASD criminal population. Did a little bit better on that. And so overall suggestibility, again, significantly worse than the normal population, but relatively consistent with those with intellectual disabilities and the clinical population of people with FASD.
All right. Now there was a graph that I think was produced by one of the state doctors comparing Nick to individuals in the juvenile justice system. And did you review that? I
did.
And can you show us the graph that you made of that information?
Yes. Let's see. Yeah. So the purple dots, this was a study from Canada of juveniles in the justice system. These were age 12 to 18-year-olds. So mean age was about 15, a little bit younger than Mr. Cruz at the time of our testing. They were also diagnosed using the Canadian FAS guidelines. The Canadian guidelines are more restrictive than the guidelines that I use. Instead of that, identifying the deficit at 1 standard deviation below the mean like I do based off of the CDC, they use a cutoff of 2 standard deviations below the mean. So a person has to be moderately impaired in order for them to identify as an impairment at all. So it was a little bit more restrictive group. So as you might expect, Mr. Cruz was doing a little bit better. But this green swath that you see here, that is the standard deviation range that was reported in the study of the juveniles, the youth with relating to FASD. And so in nearly all, so there's 20 scores that are represented here. In 13 of them, 13 of them, Mr. Cruz's performance was within the range of 1 standard deviation, either above or below the mean. So for the most part, fairly consistent. There's a couple places where he's significantly better. This was in that list learning task. He did better on that than that group. And then he did worse on this motor coordination task of the finger tapping, being able to tap his fingers quickly, so motor speed. He had difficulties. But for most of the other scores, it was within that range. So pretty consistent, even though these individuals were being diagnosed with a much more restrictive system.
Okay. Now, if you would, I'd like you to summarize your findings of Nick's testing and his your examination of his testing across his lifespan?
Right. So based on the current testing, as I said before, Mr. Cruz is demonstrating deficits in 9 different domains of functioning. Splits across domains of intellectual functioning. We talked about that. Academic impairments, all 3 aspects that were assessed or that were part of the assessment here. And so as far as the splits across domains, these were found early on at age 5. Academic impairments, like I'd said, found throughout his schooling on standardized testing. Impairments in learning and memory of complex language and visual spatial information. Memory impairments were found on testing when he was 5 years old. Visual spatial construction, poor organization, again, on testing that was done when he was 5, he also demonstrated impairments there. Fine motor speed, his mother had indicated that at 3.5 years old, but there was no testing that was indicating it directly when he was younger. The executive functioning, so he was demonstrating impairments in idea generation, inhibition, able to quickly shift the focus of attention, working memory, initial problem solving, those perseverations, doing things over and over again, even if they're not helping you, and the suggestibility. There were impairments in executive functioning found when he was 5 years old. Expressive and receptive communication, both on direct testing that was done currently and on informant report when he was 3.5 years old, and also on testing that was done both at 3.5 and 5 years old. Daily living skills was found on current testing, as well as found at age 3.5 based off of his adoptive mother's report. And the socialization functioning, primarily reported both by the mother when he was 3.5 and also noted in the school records or in the evaluation when he was 5. So he's demonstrating deficits in 9 out of the 11 domains that were assessed currently.
Okay, and then at the bottom there regarding the significant functional disabilities?
Yeah, so we're seeing that, yes, there are a lot of deficits across a lot of domains, but you can have deficits, but not in several domains, but not that widespread as far as how many scores were impaired, or looking at kind of what the severity levels are. So overall, from that graph that we looked at earlier, 53% of Mr. Cruz's current test scores were within the impaired range. 53%, more than half of those scores were in the impaired range. Of those, 40% were in either the mildly or mildly to moderately impaired range. So the large majority were in that range. But still, 7.5% were in the moderately to severely impaired range, and 6% were within the severely impaired range. So not only are we seeing a lot of scores that are impaired, typically with a normal individual, we actually do anticipate seeing impairments on neuropsychological testing, but usually that's 15%, maybe as high as 20%. Here we're seeing 53%, far in excess of what you'd expect to see if he was a normal individual. And we're seeing mostly mild or mild to moderate, but still areas of quite significant, much more significant impairment. And regardless of what that level, it has an impact on his functioning.
Now, you mentioned on that graph that had that you added the green swath to show the range of standard deviations from the norm. And I think you said that was from a study that was based in Canada. Is that correct?
Yes.
And you said that the diagnostic or criteria in Canada is more strict. And just tell me briefly what you mean by that.
Yeah, so like I said, on the CDC's guidelines that I use for my evaluations requires deficits of at least 1 standard deviation below the mean, so 16th percentile. The Canadian guidelines also are looking for deficits in at least 3 domains, but they have to be 2 standard deviations below the mean, so basically at about a 2nd percentile. So that's the Canadian guidelines that they use.
Are there guidelines that use a standard deviation other than 1, as the CDC uses, and other than 2, as they use in Canada?
Yeah, there's another another group. Hoyme was the lead author on it. In 2015, they published their attempts to more operationalize the IOM's guidelines. And they set the cut point at 1.5 standard deviation below the mean. So basically, they're looking for it's got to be mildly to moderately impaired range, and not including those that were more mildly impaired. And
I know the CDC requires, I think you said, impairments in 3 domains. Is that correct?
Right.
And do some of these other criteria use a different number in terms of the number of domains that need to be impaired?
Slightly. I mean, and Hoyme talks about the Hoyme ones that are the minus 1.5 do talk about 4 domains, but they're spread out. So it's IQ, there's neuropsych, there's behavior, and there's developmental. So it's looking at those areas in slightly different ways than the CDC does, but it's still looking at kind of behavior over looking at those impairments in behavior.
So if you apply the different standards as identified by the CDC or by Canada or by the IOM, if you apply different standards to Nick's neuropsychological testing, does it change your opinion about what his neuropsychological testing is indicative of?
No. If you use the Canadian guidelines, he would still have deficits in 7 domains.
And is the Canadian one the most stringent of the ones that you're aware of?
Yes.
Okay. And that opinion that you have based on his testing and your record review, if you would just summarize your ultimate opinion for us.
That Mr. Cruz's pattern of functioning is consistent with the diagnosis of neurodevelopmental disorder associated with prenatal alcohol exposure, as in DSM-5. It's also consistent with the IOM and CDC guidelines for pattern of neuropsychological impairments for individuals with FASD. And it is consistent with the medical diagnosis of alcohol-related neurodevelopmental disorder, or ARND, that was made by Dr. Jones, who you'll hear from later.
Okay, John, if I may have just a moment.
Sure.
Just one last thing. Dr. Connor, if you can hear me.
Yes, sorry.
That's all right. Going back to the actual administration of this neuropsychological testing that you did of Nick, the actual process of being at the jail and doing it, is there a reason why it's not recorded in some way, meaning audio recorded?
Yes.
And what's that?
Well, there's been ample research that use of third-party observation, so somebody else sitting in and observing testing be administered, whether that be a human being sitting in the room or some sort of recording device, whether it be audio or video, has an impact on test-taking behavior. It changes how the person responds. So very much the recommendation, the admonition from all neuropsychological societies is that you don't allow third-party observers. The other aspect of it is that if a person is sitting in, they are now being shown test material that is copyrighted and needs to be kept secure. And if a test is no longer secure, and let's say the questions are released in some way, then that test would likely lose its validity, and later down the road, we wouldn't be able to use that test. So we have ethical and legal requirements that we not allow the test that we protect the security of those tests. So for both of those reasons, we don't allow, and I do not allow, a third-party observer, or whether it be a human or video or audio recorded while I'm doing testing.
All right. Thank you, sir. I appreciate your time very much.
Thank you, ladies and gentlemen. We're going to take a 15-minute recess. Please do not discuss the case. Please leave your notepads behind. Okay, the jurors have been excused. We're gonna be in recess. It's 3:47. I'd like to start back up in 15 minutes. I have to give the jurors, you all know, a little bit longer because there's so many of them. may be seated and state when you're ready.
Thank you, Your Honor. Good morning, good afternoon, Dr. Connor. How are you?
I'm doing well, thank you.
Good.
How about yourself?
Good. So let me start off. Are you board certified in neuropsychology?
I am not.
How do you become board certified in neuropsychology?
It's a voluntary process, not required in order to practice as a neuropsychologist, but it requires a period of study, to take a written exam, then to provide various work samples that are reviewed, and then eventually participate in an oral examination.
And you have not done that?
That's correct.
Okay. Are you board certified in forensic psychology?
No, I'm not.
Do you have any formal training in forensic psychology?
No.
Are you board certified in any discipline?
No.
Do you recognize the American Academy of Clinical Neuropsychology?
Yes, I do.
Okay. And do you recognize that as an authoritative source?
It's one of the several neuropsychological societies in the United States. It's a very good one.
Okay. And do you have the American Academy of Clinical Psychology listed on your CV?
No, I have the American Academy of Clinical Neuropsychology.
Oh, I'm sorry, neuropsychology.
That's okay.
Yes.
Yes.
I thought that's what I was speaking about.
Okay.
Okay. Yeah, and you're a member?
I am.
Okay. Are you a full member or an affiliate?
I'm an affiliate member.
Okay. Is it against the bylaws to put in writing or orally that you're a member of the American Academy of Clinical Neuropsychology?
That I'm not aware of that.
Okay. Well, if you get a chance, I suggest you check. I think it says that you have to be, to say you're a member of the American Academy of Clinical Neuropsychology or to print it. And I may be wrong, but it indicates you can't do that unless you're a full member.
Your Honor, just object to testifying by counsel, please.
Overruled.
Okay. Okay. Are you licensed to practice psychology in the state of Florida?
I'm not.
How many criminal cases have you been involved in where Dr. Richard Adler has been involved?
I do not know the exact number.
Hold on just a second, please. What is the objection?
Relevance, please.
Do you want to argue this?
Can you speak to the lawyer's sidebar, please?
Okay, Dr. Connor, you can answer. You want me to repeat the question?
Please do.
Sure. How many criminal cases have you been involved in when Dr. Richard Adler was also involved in the same case?
I do not know the exact answer to that.
Okay.
It has been a number of cases.
Okay. If I said approximately 150 cases, the government in your career?
I'm sorry.
Go ahead. Go ahead. You were going to answer. I don't want to interrupt you.
I've testified in one of those cases. I've had a couple of cases.
Okay, so once. Okay. So how many cases, let me put it this way. What percentage of your income is derived from you being hired by defense attorneys in criminal cases?
I don't know the specific percentage of my income. I know the percentage of my work that is criminal versus clinical.
So you have no idea what percentage of your income is derived by being hired by criminal defense attorneys in criminal cases?
I don't track that number in my software.
And you have no idea?
I do make more from criminal cases, for sure. And about 60% of my work is clinical.
So do you have no idea how you would answer my question? How much of your income is derived by being hired by criminal defense attorneys in criminal cases?
I derive more income from criminal cases than I do from clinical cases, yes. I don't know the exact number.
Okay. And you don't know what the money number is? Is that what you're saying?
No.
Okay. When were you hired in this case?
I'm sorry?
When were you hired in this case?
I was contacted in December of 2020, and the contract was finalized in March of 2021.
Okay. And when?
March
Of 2020?
2021.
2021. Okay. And then you met with the defendant on May 20th, 2021?
Correct.
Okay. And you met with him for 5 hours?
Yes.
And where was that?
That was at Broward County Jail. I don't know the specific name of it, sorry.
Okay. That's fine. And it was all in one day?
Yes.
And you did some interviewing?
That's correct.
What percentage of the 5 hours did you do interviewing?
That's usually about 1 hour.
Okay. Did you videotape that 1 hour?
No, I did not.
Did you audio tape that 1 hour?
I did not.
Because that wouldn't be interfering with any of your testing, would it?
No, but it is also not part of my practice to video or audio tape any of my evaluation.
Okay. Did you know in the state of Florida that defense counsel has a right to be present during any testing or any interview of one of their clients?
I was made aware of that.
Okay. And are you aware when a state expert examines a defendant in a criminal case, not only does defense counsel have a right to be there, but it has to be videotaped? Did you know that, Dr. Connor?
I don't recall that.
Your Honor, may we have a sidebar, please? Sure.
for a moment, there's too much commotion and back and forth that needs to go on for you all to be sitting here with that annoying white noise. So, please don't discuss the cases. The case, please leave your notepads behind, and we'll be back with you shortly. Thank you.
I just want to clarify precisely what my objection was.
Okay, just hang on one second.
Sure.
Please. First of all, this was an agreed order. This is not my order. This is agreed. I knew by the way it's formatted.
Well, with all due respect, it is a court order.
Okay, a court order, but
Agreed by the parties.
Yeah,
which
we're not
means,
saying-
that's why I'm not so familiar with the issue, because when you all agree, I read the order and I sign off on it. So, you're right, it's still a court order, but,
Just so the objection is clear for the record, what the defense is objecting to was Mr. Satz's statement that the law in the state of Florida requires that expert evaluations be videotaped. The law in the state of Florida does not require that. It happened in this case by agreement of the parties, as the court has just noted on the record. The order that you signed, I believe it was February 28, 2022. The reason why the defense proceeded to ask Dr. Connor about his procedures and methodology that he implements as to whether or not he videotapes expert evaluations of criminal defendants, that is not his practice. And like what I already just said, is throughout the depositions of our experts, the state has made inferences that our experts were doing something wrong because they didn't videotape. So by the state asking Dr. Connor if he's aware of a law in the state of Florida that requires the videotaping of expert evaluations of criminal defendants, which it does not, that in fact is misleading the jury into thinking that Dr. Connor did something improper by not doing it.
okay.
Does that make sense, Judge?
It does.
Okay.
But I think that the state can just rephrase their question, and then if both sides agree to just stay away from this area, because this is gonna be confusing.
I'm fine with that.
The witness is gonna have to concede that although that's his practice, that under certain circumstances, it's appropriate. For example, when a court orders it.
We wouldn't have agreed to it if the law wasn't, I remember the law was provided, and that's why because our experts don't want to do it either. Why would we do that?
Mr. Sachs, I don't remember. When you all agree to something, but I don't do the legwork and the research, I leave that up to you. So maybe the best practice would be to excuse the jury for the evening. It's 4:30. You all can look into this. We can reconvene 30 minutes before the jurors come back tomorrow, and you all can show me what you agreed to.
Okay.
But I seem to have a recollection, Judge, that because you were only allowing 2 experts in for the state to evaluate the defendant, you wanted to videotape so that you could show it to your other experts.
No, that was an advantage of it, but that's not why we agreed to it. We almost lost an expert because he said it,
No,
you know.
I need to refresh my memory, quite frankly, and I
Okay,
can't do it right now because I really don't remember this at
We'll
all.
accept your suggestion that we recess and we research it.
Okay, like I said, I sign off on it when both sides agree. I'm not as involved in the research, so.
There's been a lot of pleadings, and I have to review them too.
Okay, so, I will have, how about if we reconvene tomorrow morning at 9 o'clock and I'll have the jurors here at 9:30? Do you think that will give us enough time?
Perfect.
Or is there any way we can just skip this particular issue and have him continue his testimony until 5, and then, you think he'll be going over till tomorrow, Mr. Sats, and then we can deal with that issue since we already have the witness here?
I'd rather deal with it now so we get a flow of the,
It feels like it's been a long day for Monday. I know we didn't start till 10:40, but we all started earlier.
Yeah, we just had 2 other experts that we flew in for tomorrow, but
Well, since this person is on, I don't know what else to do. It's 4:30. I need to review this issue. Go back and look through my notes. I'm not able to do it on the spot. I'm trying to, but I'm not finding anything, and I want to be able to be informed. So do you want to start earlier? We can start at 8:30 and have the jury here at 9, if that helps with your witness availability.
is he there? Oh, he's in Washington State, so that's 5:30 in the morning for Dr. Conner.
Oops. There's a 3-hour time difference?
Apparently.
So he was gonna start this morning at 6?
Yes. 6:30.
Okay, so what was your suggestion?
I would like to continue through the rest of the day, but if the court doesn't want to, we'll just start at the same time tomorrow.
Okay, but I don't want the jurors waiting, so how long will it take to hash out this issue, and what time are we meeting before the witness continues?
Well, it's like you said, Your Honor, it's 4:30. Why don't we just start tomorrow?
That's what I'm saying, I'm just
Okay.
trying to figure out the time. Okay, I'm just gonna make a decision. Tomorrow, I'll have the lawyers back at 9, I'll tell the jurors to be back at 9:30.
Okay, great.
And your witness, 9:30, please. Hopefully he's a morning person. Sorry about that, I mean, it's,
Oh, no, it's not your fault.
okay, so I'm gonna have the bailiffs excuse the jurors for the evening, tell them to be back at 9:30, and, we're in recess. Dr. Connor, we are in recess, please, Dr. Connor, this is Judge Scher, can you hear me, sir?
Yes, I can hear you.
We're gonna recess until tomorrow. I just want to let you know that, the rule of sequestration has been, invoked, so please don't discuss your testimony. Between today and tomorrow, he's an expert witness. But you're not gonna be consulting him regarding another expert testimony between today and tomorrow.
The only thing that I would communicate with him would be about his availability in the morning and what time.
Okay, well, that doesn't count. That's scheduling. Okay. All right, thank you. The attorney.
So I'm dismissed for the day?
Yes, sir. The attorney, Mr. Secor, will be in touch about what time we need you back tomorrow, okay?
All right.
Why don't we do
That's
while the witness is
problem.
online? You can tell us what. Want to be available first at podium.
But he wants to, okay, what time, sure, approach the podium. This seems like it's overly difficult task.
Hey, Don, can you hear
I'm
me?
making it overly
I can hear you.
We have an issue that we need to resolve pertaining to your cross-examination, and we were gonna try to get it done today, but can you testify tomorrow morning?
I have an in-custody evaluation scheduled all day tomorrow.
Okay, so, here's the thing, sir. You have an in-custody evaluation at 6 o'clock in the morning?
I have to be up to the facility by 7:30,
You're gonna have to. push
and
it
it's an
back.
hour drive from where I live.
Sir, I'm sorry, things happen, you're gonna have to push it back. I need you here, you're under subpoena, I'm not excusing you. Please make yourself available at 9:30 so the state can cross-examine you.
Very well.
All right, thank you.